It looks like
I see the director. I see the assistant city attorney. I saw Ms. St. Louis. I don't know if you want me to start or.
Yeah, I was just allowing for the attendees to start to file in. It looks like I've had about 6 people, and it has been moved since then. So, yes, we're ready to begin. I'm gonna begin recording.
Okay, so 1, 2, 3, go.
Yes.
All right. Good morning, everyone.
Recording in progress.
Good morning, everyone. I'm going to call the special magistrate hearing for the city of North Miami for August 19th, 2022 to order. It is on or about 9:30 a.m. I am the special magistrate today, Rafael Suarez-Rivas. We will give now a very brief opening statement. I think I'll just do that now and get that out of the way. The purpose of the hearing is to determine if a code violation exists on your property as observed and cited by the code compliance officer of North Miami. If the city is not able to prove its case, then I will dismiss the case and you may leave. The proceedings are recorded. All persons who are speaking should do so one at a time, and your testimony should be audible on the recording device. Please, no interruptions, heckling, or verbal outbursts. If English is not your primary language, please inform me when I call your case. We have a translator who will assist you in the proceedings. When your case is called, the property owner, an agent for the property owner, and any witness who is in addition to those that you have to come forward to the camera and be ready to speak directly into the microphone. Start by saying your name, your business or mailing address, and your relationship to the property. If you are not the property owner, an attorney representing the property owner, then you must present a notarized power of attorney affidavit in order for your testimony to be taken on behalf of the property owner. For new cases, you will be asked for the record if you are aware of and understand the violation that is being heard today, and you understand what is required to resolve the violation. Please answer accordingly. The city will present its case first. Then the property owner, the violator, will be given an opportunity to testify on its own behalf, to bring forward any witnesses to testify, to present any evidence and photographs into the record if not already done so in the past, and to cross-examine any city witnesses. Following the case presentation, I will issue a finding of fact on the case. If I find that a violation of the city code exists or exists on your property, then depending on the case type, I will set an abatement date for the violation to be resolved that is corrected. For repeat violations, I will impose daily fine amount. For new non-repeat violations, my order will include an abatement date by which you must resolve that is cure or correct the violation, and a daily fine amount that I may impose at a future hearing date or at a future date should the violation not be resolved by the abatement date. For appeals of civil citations, I will enter a ruling either affirming or reversing the citation. If the citation is affirmed, I will enter an order assessing the civil penalty, costs, and a compliance date. If the violator does not comply with the compliance date, continuing fines and penalties will be assessed. If I find sufficient cause to postpone enforcement at this time, I will table the case to another hearing date in the future if that is necessary. If you do not agree with the finding of fact ruling, the property owner or the city may appeal the administrative order to the Circuit Court Appellate Division, and appeal must be filed within 30 days of the date of execution of the administrative order to be appealed. In accordance with Florida law, if a person decides to appeal any decision by the special magistrate with respect to any matter considered at the proceedings, the person needs a verbatim record of the proceeding. The record includes testimony and evidence upon which the appeal is based. The cost of obtaining a record shall be the sole responsibility of the appellant, that is, the person who is filing the appeal. It is recommended that the persons who plan to appeal should provide their own court reporter at the hearing, at the proceeding if possible. Pursuant to city codes, if the city of North Miami prevails in prosecuting the case before the magistrate that is a violation is found, the city is entitled to recover all costs. The current cost assessment is $100 per case. That's applied uniformly if there is a violation. One city records an order that imposes a fine and authorizes a lien against the property, the city will charge you additional administrative fees to record and release a lien. Now, if you're giving testimony today in the case, you will raise your right hand as the officer issues the oath. The code compliance clerk will announce any additions, corrections, or deletions to the hearing agenda, and he or she will call the first case. Thank you.
The clerk can go ahead and provide her operational instructions at this time.
Right. We have the Pledge of Allegiance and the swearing in left, so we can proceed with that.
Good morning, can everybody hear me?
Yeah.
And thank you for participating in today's special magistrate hearing. I'll review the process by which today's hearing will be conducted. Make sure your device is muted at all times unless you are giving testimony on the case. If you are using two devices to participate in today's hearing, be sure your audio is only enabled on one device. When your case is called, if you are signed into Zoom, you will receive a notification giving you access to audio and video so that you may give your testimony. If you are physically here in person and wish to give testimony, you must sign in with the clerk up front and await a text message indicating your case is ready to be heard. Upon receiving that message, you should immediately come to the Code Compliance Office to be provided access to the computer. If you would like to speak on behalf of the case, once the case is called, you should click the raise hand button to be acknowledged. Before giving testimony on your case, please state your name, property address, and relationship to the property. If you wish to have an interpreter assist you during your case, please indicate that when your case is called. Your magistrate, that concludes the instructions.
Thank you very much. The Pledge of Allegiance needs to be given.
We have someone here from the North Miami Police Department that's going to administer the pledge. I'm going to share the flag on our screen. Madam Officer, are you ready?
Hello, can you guys hear me?
Yes.
Okay, we're ready. I pledge allegiance to the flag
Of the United States of America
and to
the
the
republic
for which it
it
stands,
stands,
one
one
nation,
nation,
under
under
God,
God,
indivisible,
indivisible,
with
with
liberty
liberty
and
and
justice
justice for all.
At this time, if I can keep all city staff with cameras and audio enabled, please, in order to have the oath administered. Anyone from the city that's going to be giving testimony, please enable your audio so we can hear your. First, can you enable your audio, please? Thank you. Madam Officer, can you?
Yes, ma'am.
Okay.
Do you swear or testimony
You are about to hear and you will be the truth, the whole truth, and nothing but the truth. If so, say aloud, I do.
I do.
Thank you. If the translators can now enable their audio and video to be administered the oath.
Okay. Do you solemnly swear or affirm that the translations which you are about to give in these proceedings will be accurate and correct to the best of your knowledge, skill, and ability? Say I do.
I do.
I do.
Thank you.
Okay, Madam Director, I noticed that there are not any civil violation ticket appeals on this agenda. As to the new business, the remainder of the agenda, are there any additions, modifications, deletions from the agenda, please?
There is one case that was postponed, which is item number 27, Enterprise 305 LLC, case number CESEA 2021-0002. This case is postponed. And that concludes all the deletions for today.
Okay. Well, then we may call the first case and proceed efficiently but deliberatively through the agenda. So we may go ahead and do that.
problem. The first case I'll be calling in today is item number 39, Oxford Court Condo, case number MGIO 2022-00176. This case was previously found guilty with an abatement date of August 5th, fine set at $500 plus $100 court cost assessment in the officer Jonathan Menesher.
I have a Michael is here on behalf of this property. Michael, if you're here, if you can enable your audio and video.
Well, good morning. This is Michael, Etienne, attorney at law. I'm here on behalf of Oxford Court Condominium Association.
Let's hear from the city first, including any testimony recommendation, and then we will hear from Mr. Etienne, Attorney Etienne, the respondent.
Okay. Good morning, everyone. Code Officer Jonathan Lemestry, and this case is being heard for the second time. On January 19, 2022, I opened a notice violation in regards to water leaking into the condo unit. This case is unique in the fact that the condo owner lives on the third floor. It's a 3-story building, and water is leaking through the roof, from the ceiling onto their floor. I opened the notice violation on January 19th, mailed the notice violation, posted the notice violation at the property. As of the final reinspection date, nothing has been done in regards to the roof leak. I believe the tenant or the condo owner is here as well. Jerry, I don't know if he's here as well.
I'm sorry, I didn't know someone else was here.
Witness.
I have a Cersei Edward with their hand raised.
That's probably them.
Okay, let me give them access. And then clerk, if you can swear in, I guess, whoever this additional person is, I'm not sure if it's the tenant or. Cersei Edward, can you enable your audio and video, please?
Yes, this is Cersei Edward.
Yes, I'm Cersei Edward.
Peggy, can you swear in, please?
Please raise your right hand now. Please solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth. So help you God. Please say I do.
I do.
Ms. Ward, what do you want to say about this case? What do you want to say about the leak?
Can you give me a context there, please?
Creole interpreter, can you assist, please?
Hi. Donc, Madame Edouard, qui ça voulait dire concernant propriétaire?
Oui, ça me dit que on doit couler depuis presque dépassé des ans. J'ai fait ma connaître ça, il vient lui checker, lui dit que la branche, la faire ranger, et puis jusqu'à maintenant, rien pas jamais fait de loi toujours à couler. Il coulait pour à côté dans bedroom dans chambre avec dans ici ça fin ami.
Excusez-moi, dit bon chambre qui peut dire encore
avec dans point de côté ici il fait connaître que c'est ici qui coule de l'eau les pas la pluie et si toujours marcher bah ouais de l'eau c'est chaque la pluie de l'eau a coulé et il coulait en pile.
All right, so what I want to say is that I have a water that's leaking here that has been going on for almost over 2 years now. I informed Michael, he came and checked it, and said they would have it fixed, but nothing has been done till this day. And the water leaking is happening in three different parts. It's in my bedroom, it's in the corner by the AC. And they said that the AC is what is where the water is coming from, but when it's not raining, the AC is on. We never have any water leakage. It's only when it's raining that I see the water, and it's a lot.
So the testimony is that water intrusion or leakage into the condo unit occurs when it rains, is basically what you're saying, right?
Donc, témoignage là, c'est que dans le condo, alors l'eau qui a coulé, ça seulement fait la pluie a tombé. C'est ça, ouais?
Oui.
Yes.
I understand her testimony. Is there anything else you want to say at this time?
Alors, moi, je comprends le témoignage. Est-ce qu'il y a quelqu'un d'autre qui a dit encore pour nous?
Mais ça que m'avait dit, gagne parti dans mien, quand là, côté boy, c'est qui presque et fin gâté net. Corrigène. But les fini con l'autre point qui collait encore avec 305 là, parti ça encore presque by gâté net tout. Et puis gagne l'autre côté encore dans mi-temps et chambre encore qui gâte encore que fin aussi que il pas un arrangement qui fait pas une décision que m'a perdu toute partie chambre dans la qui a tombé parce que si tant pour la pluie a tombé en pile gens qui tombé pour qu'on là il a tombé.
Well, what I want to add is that there is a part of the wall in the house here that's not good. It has a lot of corrosion, and also the corner that's by the 305 unit also is not good, and also in the middle of the room it's not good at all. And if I see that there's no arrangement or no decision is made to get that fixed, it may fall. And if it was raining as much as it used to before, it would have fell before.
Okay, I think I understand. Thank you. Is there anybody else who wants to say anything? Mr. Etienne, do you want to say anything?
Of course, yeah, we have an entire argument put together. Okay, so let me clarify something. According to this witness testimony, she alleges that I went into her unit and I told her that we were going to fix the leak. That is incorrect. We did go inside the unit and we saw exactly what we expected to see. Let me give this court, this hearing officer, a historical background here. You ruled probably 3-4 months ago on this matter. I wasn't in town, I wasn't available. We asked for a continuance, and apparently it never happened. So on June 17th, we did file a writ of certiorari so that we can overturn this hearing officer's ruling, so that we can have an opportunity to be heard. In the middle of that writ, the court ordered the city of North Miami to rule to show cause as to why our writ shouldn't be granted. In return, the court ordered us to order transcripts so that we can eventually give the city an additional 30 days to reply on the writ. In the middle of that, during the appellate process, it was brought to my attention that this matter was placed back on the calendar. From what I understood, it was supposed to be a rehearing. So because of that, in the middle of our appellate process, we filed a notice of voluntary dismissal because at that point, our appellate writ was moot because we had an opportunity to be heard. So just to be clear, from what we understand, this is basically a rehearing to give us an opportunity to present a case and explain to the hearing officer what we couldn't explain 3-4 months ago when you originally ruled on this matter. First and foremost, if Crystal don't mind, if you can put up the exhibits that you put up regarding the photos that she submitted. because her testimony is incorrect and it isn't credible, and we're going to basically explain exactly what our position is. That's a pitch. I'm sorry. Okay, so we can do it one picture at a time so I can explain to the court. And as she testified, I actually went in there and we noticed it. So we can stay here, Crystal. Your Honor, what you're looking at basically the wood panel that is covering that pancake AC unit that's on the ceiling of this unit. The condo was built roughly 1973, and at the time it was built with pancake units on all the ceilings on our floors. We have 39 units in this building. There's 13 individual units on the roof, on the third floor, which shares the exact same roof. 13 individual units. This is literally the wood panel that covers the pancake AC unit that is lodged in the cylinder. Crystal, can you go to the next picture, please? This is a picture. These are pictures of ceilings where water damage has accumulated, not on the roof, but on the ceiling of this particular individual unit. And if you look at every single one of these pictures, Your Honor, they are interior pictures that shows you evidence of a leak in a ceiling, not a roof leak, but a leak in a ceiling. So what's been going on with this building? The building was built in 1973. This building is encased with cast iron plumbing. There's vertical stacks that runs through the roof, which has an open airway in the roof, and it goes all the way down to the first floor. There's cast iron plumbing. About 14 unit owners, including myself, I owned 2 units. I owned 2 units in this building. Now I own 1. We had to open up our walls and remove vertical stacks that goes all the way up to the ceiling, all the way down to the flooring. Now, the reason why these photos are important, and I'm going to basically take it one step at a time because we need to make sure we have a clear record for appeal. The violations that Oxford Court Condominium Association is accused of violating, ordinance number, I guess, section 5-20 of the North Miami City ordinances. So I'm assuming it's ordinance number 1380, section 5-20. The ordinance violation that we are accused of violating is watertight and watertight conditions. And I'm going to read to you section 5-20 so that I can read it in the record. Every structure used for human habitation shall be so maintained that it will be weathertight and watertight. Exterior walls, roofs, and all openings around doors, windows, and chimneys, all other parts of the structure shall be so maintained as to keep water from entering the structure. At this moment, I'm going to stop right here in the middle of the ordinance. There has been no evidence of exterior walls, roof, and all openings around doors, windows, chimneys, or other parts of the structure, so that shall be so maintained as to keep water from entering the structure. There has been not a single shred of evidence submitted to this court to suggest that our roof or any exterior walls are leaking. Only thing that the court have seen thus far are pictures of interior walls. And again, we have roughly 13 to 14 units. They've dealt with the same issues, and we came up with a procedure to fix that, but we'll get to that later. The ordinance continues on by saying damaged materials, including the use of a blue tarp, must be promptly replaced. No blue tarps on the roof, no evidence thereof. Lastly, all parts of the structure that show evidence of dry rot or other deterioration shall be repaired, replaced, and refinished to be in conformity with the rest of the structure. Your Honor, there is not a single evidence, with the exception of interior water damage that's coming from the area of a pancake AC unit. There is no evidence submitted to this court where you see any dry rot or other deterioration of the roof. Now, let me explain to this court what happened recently. So I'm going to stay on the roof, and then we're going to go in and talk about our bylaws. On August 20th, 2018, and this was submitted into the evidence, our building was inspected for our 40-year recertification. Miranda Engineering and Construction Incorporated, their office is located at 930 Southwest 16th Street, Boca Raton, Florida, 33486. They can be reached at telephone number 954-461-9785. On the date mentioned before, on August 20th, 2018, they came out and inspected our building, and these are licensed engineers, licensed construction individuals in the state of Florida.
On
In
what date
fact,
did they? I'm sorry. On what date did they inspect your building? On what date again?
they inspected it on August 20th, 2018. When they inspected our building, that was roughly 4 years ago. Well, 3 years and 2-3 months ago. The president of this particular organization is Enrique Miranda. Apparently, he has a PE general contractor. He's a general contractor and
Yes,
a
yes.
PC. I don't know what that is, but I have to read it into the record. His credential numbers. So his PC number is 36129. His MEC number is COA 4728. Now, on the page that we submitted via the last time we submitted the exhibit. Now we're talking about the roof. We're not talking about the interior portion. We're talking about the roof. They actually went on top of the roof, and they conducted an assessment that was required by county law so that we can obtain our 40-year recertification. Subsection 6 under floor and roofing system. Now this is from licensed engineers, licensed general contractors. This is a report that was submitted into evidence, not hearsay testimony, not evidence from a non-certified roofer, but these are certified engineers. Subsection A, 1, they describe the roof as being flat, wood, trusses with parapet, wall sheeted, and it concludes in good condition. Now, as this court may or may not know, they have 4 tiers. They have excellent, good, fair, and poor. Good condition. So we met the second tier. Subsection 2, note, water tanks, cooling towers, air conditioning equipment, signs, other heavy equipment and condition of support, only slit unit condensers, good condition. Subsection 3, note, types of drains and scuppers, whatever that is, and condition, the assessment from this particular engineer, good condition. Now, Your Honor, this was submitted into evidence where we have licensed engineers and contractors that concluded that we met the second highest tier. It goes from excellent, good, fair, and poor. We've met the good threshold, and that was only roughly 3 years and a few months ago. Now, where do we stand here? The city is required to prove that our roofing, according to the ordinance that we're being accused of violating, was in bad condition. This court have seen no evidence from the opposing party that our roof is in bad condition. What you do have, you have a young lady who owns a unit in the building. Now, we've had litigation on this matter before, a litigation that was recently won, and this was Jackie versus Oxford Court Condominium Association. This was before Judge Rodriguez fought. This matter was recently dismissed after 3 years of litigation. And of course, they owe now a lot of attorney fees that they can't pay. But we've literally litigated this matter because the fact that the cast iron plumbing that has an opening up in the roof and runs down to the ground, we literally had to come up with a procedure so that we can avoid expensive litigation because the bylaws, and we submitted this into evidence, indicate that the owner, the unit owner, is responsible for the electrical, the AC, and the plumbing within their units. So what did we do? During our 2018 annual meeting, this meeting took place, and this was also submitted into evidence. The minutes of the 2018 annual meeting and budget meeting of the Oxford Court Condominium Association. We had an annual general meeting on January 17, 2018. At that particular meeting, the association as a whole, by a majority vote, which was a 14-0 nay vote, it was a majority vote. We ruled to follow these particular procedures when a leak happens inside a unit. And here it is. I'm going to read it into the record. And of course, I have to bloviate, Your Honor, because I want to make sure that I have a clear record. Subsection 5. At the time, one of our board members, Dina C, makes a motion to approve the following procedures when dealing with faulty pipe leaks. 1, the board of directors may impose a special assessment on all affected unit owners to enforce these procedures. 2, each unit owner is responsible for all the pipes within their interior doors of the unit, as stated in our bylaws and regulations. 3, if a faulty pipe is leaking and the portion of the leaking is the portion that must be repaired, the unit owner shall fix that portion of the pipe at the cost to the unit owner. 4, here it goes. If the entire vertical or horizontal pipe needs to be replaced per a licensed plumber, Each unit owner shall share the pipe, the share in the pipe shall remove all the drywall, tile to fully expose the pipe at the cost to the unit owner. Now, once that's done, Your Honor, once the drywalls and 14 other units had to undergo the exact same process. One unit owner decided to take us to court and they lost, but everyone else had to follow these procedures where in your interior walls, you have to remove the drywall so that we can see the primary source of the leak. Every single time the drywalls were removed, it was either a vertical stack that came from the roof down, and I had pictures of the vertical stack, but we didn't get to submit it into evidence last time, where the cast iron plumbing is deteriorating. So that means that when it rains and that vertical stack is open, the water falls into that vertical stack and leaks through the drywalls. That's one. If that wasn't the case and those vertical stacks weren't removed, it was always the air conditioning unit and the condenser lines that was leaking in the ceiling. So our position is, this particular unit owner, the Florida statute gives the associations the authority so that we can impose bylaws, rules, and regulations. And this is the Florida statute. She refuses to follow the procedures that are laid out in our bylaws. Once the walls are open, and as the court concluded last time, well, the circuit courts, once the walls are exposed and we see the primary source of that leak, at that moment, we can be held responsible for any damages that may come from the roof. But at this moment, during this juncture, she, one, refused to follow the procedures of the bylaws and rules and regulations, which she knows about. All she has to do is open up the wall so that a licensed plumber, a licensed person can come in and ascertain the source of that leak. And two, once that happens, then the association would, like we said here, we would call a special meeting and impose a special assessment to fix what needs to be fixed. But there's a procedure that needs to be followed here that she refuses to follow. So just to sum this up, Your Honor, so every unit owner on the 13th floor shares the same roof that she alleges is leaking. Why is it that her roof is the only roof and it's centralized? Her ceiling is the only ceiling. Our roof is only bad in one location on top of her unit, and her unit is centralized in a general area. So why is it that no other?
What do you mean it's centralized in the general area?
Meaning that her roof, where her unit is at, is shared by, there's units on the left, unit on the right. So her roof is not only her individual roof. So that means, so if there was a roofing issue where her particular unit was leaking, then the unit to the right and the unit to the left would also suffer water damages. Why is it that none of them suffered water damages? So our position is, all she has to do, Your Honor, is open up her walls, follow our bylaws and procedures, which we have enacted pursuant to the Florida statutes would give us that right, and stop trying, because then, let me just say, until she follows that, we're not going to fix it. She's going to continue dealing with damages. The only thing that can happen, the city can impose a fine. The fine is going to hurt her more than anyone else, because what happens is the fines eventually get maxed out, but if she ever want to sell her unit, she ever want to refinance, she would be prohibited from doing so because of the fines that she caused the city to impose. So that would adversely affect her property value. It wouldn't affect us. So our position is, we are in compliance with the ordinance that we're being accused of violating here. And what I am going to ask, though, Your Honor, because I thought that I submitted a picture of the cast iron plumbing that came out of the walls. I wanted to submit that into evidence. What I am going to ask is so that we can reset this so that I can submit the actual photos of cast iron plumbing that's coming from the roof, open, down into the ceiling that goes through her walls. We wanted to submit photos of those exposed cast iron, and if we can reset this, I'm sorry.
Well, you've spent. I understand your. I'm going to ask the city if they have any opinion on that, because I'm ready to issue a ruling or adjudication unless the city wants it to be reset. Because I'll tell you, I understand your request for a reset, but you've made that request after tendering a quite extensive defense and giving testimony. So you should have made that request at the beginning, not at the end of 20 minutes of argument.
Well, that's not how the appellate court sees it, Your Honor. They want, in case you decide to rule in favor of the opponent, we have to have a clear record, and we learned that lesson during our recent writ of possession. But writ of search. All we're saying is we have more evidence to submit here so that this court can make a competent ruling. So we submitted what we submitted. even if you're going to rule in our favor, we want to still submit the evidence because any imposed fines is going to adversely affect her, not us. It's going to adversely affect her unit, and her unit still won't be fixed. So we're going to request that we get a reset so that we can submit additional evidence.
Well, I'm going to ask the city if they have any opinion or any regard to that, because I'm ready to make a ruling. Again, you have gone through the hearing, you have gone through a defense, you've presented testimony. I'm going to ask you something because I'm going to ask you this as an officer of the court and also as someone who seems to have personal knowledge there because you own a unit there. So, you're under oath and be mindful of your role in all those respects. Is there any other unit on the third floor with water damage?
No, Your Honor, absolutely not. We have had not one unit on the third. But again, Your Honor, just to be clear,
right?
We're not asking for a recess only for our benefit. It's for her benefit as well. If we get a 30-day recess, we show her the cast iron. I think the misconception here in North Miami is, the city's going to force people to fix X, Y, and Z. What's really happening is people are getting evicted from their homes or fines being imposed in buildings, and it's adversely affecting the owners. Our position is it's to their benefit if we show them the cast iron, we walk them through the process again so they can understand it to get their unit fixed. So, but to answer your question, Your Honor, and we don't want, and again, it's to her benefit. We don't want to just throw her to
I try to be efficient. I don't like to kick the can down the road, but
this can be resolved.
I'm going to ask the city because, again, I don't think I need to educate you on code enforcement or code compliance. What I can do is I can find that there is a violation if it's been shown or there is not a violation. As to the matters in litigation, between you and her and the bylaws and the other circuit court case, those are really private civil actions that are not, unless they deal with an appeal from the magistrate or something like that, they're really not within the province of the magistrate unless the circuit court remanded it here with certain instructions, which they did not. So I'm going to ask the city, do you want me to go ahead and after I'm maybe going to ask 2 or 3 other questions and I'm ready to issue a ruling, or do you want this reset to a later date?
The city is okay with tabling the item magistrate to allow for the property owner to be briefed, educated. Obviously, there's a language barrier, so a lot of what was communicated in today's session was not able to be translated. And so, the city is okay with granting the additional time.
Okay, so I think in light of that request and in light of the city's agreement, that this particular matter will be reset and continued to another future date where it will be rescheduled. In light of that, I'm not going to make any other pronouncements, except I will note this. Your evidence has to be submitted in advance. Do not have that other hearing date and be saying, I want to submit the report now or something like that. You must get it into the city record, Mr. Etienne, in advance of that hearing. So I would encourage you to do it forthwith or as soon as possible. And if there is any, I understand that there was a roofing engineering, and I find that that's a professional level of a report, but it is 4 years old. If there's anything more current, if there is, it should be submitted as well.
John, I just want to say one more thing. I'm so sorry. I wanted to let Suri and her son know I'm gonna be in the building in about an hour. So I'm gonna basically drive over there, leave my office and drive over there so that if they're gonna be home and I can walk them through it all, and I can almost assure you that this matter is gonna be resolved without any intervention from the city. So rest assured, if it has to be reheard, all our evidence will be submitted in addition to whatever additional documents that's needed. But I'm gonna head over there so I can walk them through the process, and I'm gonna even take her son on the roof so that he can see the roof himself. But this will be resolved before any additional.
Magistrate, I'm sorry, Magistrate. If I could just have the translator at least communicate the last piece.
Yes, they need to communicate that, and if the parties do resolve it, you also need to convey, Mr. Etienne has understood me, but uh, to Miss Edouard, that they'll need to tell the city that they've reached an agreement, because if not, this matter will be on some future agenda.
Donc,
That's
Madame Edouard, Monsieur Etienne pour aller l'autre bord, et dans environ une heure de temps, la privé l'autre bord, pour lui capable d'aller garder toute bagaille avec nous, avec petit garçon là, et y a monté en l'air tout pour capable checker, pour montrer exactement qui ça problème là est, et puis pour nous travailler ensemble, pour nous résoudre. Et puis, si toutefois nous arrivons, joignons accord et que nous rangeons toute bagaille, et faut nous informer et bureau ville là, et pour empêcher que vous mettez nous sur agenda pour nous venir appellation encore.
Okay.
I would, Michael, if it's okay, Magistrate, I would also request that whenever you do visit the property or the property owner, that you would allow the city at the same time to go in and conduct the inspection or a final inspection once you guys have come to some resolve, whether that be gaining access into the interior or, I don't know, I know our building official is on the call, but we would like to ensure that, we're able to kind of go in and conduct a final inspection upon resolution.
Absolutely.
right. So you're agreeing to that on the record.
Yes, Your Honor. Yes, Your Honor.
All right. Okay. So you have that agreement on the record. And so you will, I'm sure, be held to that by the city. So be aware that an inspection will occur at some point.
Thank you.
Yes. All right. Well, then, if that is all on this particular case, this case for the moment will be continued pending future developments. And thank you all for your participation.
Thank you.
Thank you.
Dossier apprêté en attente, Madame Edouard, pour si tu as gagné l'autre bagaille puis devant. Merci.
Oui, merci tout. Merci
Thank
beaucoup.
The next case is item number 17, Alberto Valdez Vidal, case number CEVPR 2021-00202. This case was previously found guilty with an abatement date of August 5th, 2022. Fine set at $250 plus $100 cost assessment. This person is here. And the officer is Aaron Barber.
Yes.
Yes. Let's hear from.
Sir, please raise your
Mrs.
right hand.
Yeah. Let's hear from the city first. This is customary, and then we'll hear from the respondent.
Sir, please raise your right hand.
Yes.
Raise your right hand. Do you need a translator?
Yes, please.
Here I am. Bien, señor, si por favor puede levantar su mano derecha.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
Jura solemnemente decir que su testimonio será solamente la verdad y nada más que la verdad en nombre de Dios.
Sí.
Yes.
Good morning, Aaron Barber, City of North Miami Code Compliance. As noted, this case was previously found guilty. Case was opened. Initial inspection was December of 2021 for windows installed without permits and a fence that was also installed without permits. As of this morning, I did check the system and there have been no applications made, no permits have been obtained for these two items.
What is the city? Well, go ahead and say whatever else you want to say about this as we look at the photographic evidence, which is accepted into the record without objection.
Yes, sir.
What is your recommendation?
I would recommend that the city move forward with the fines until compliance is met.
Entonces, estamos aquí porque en este caso que ya fue previamente visto, donde se le había encontrado culpable con anterioridad, esto en diciembre de 2021. Se encontraron que había ventanas instaladas sin permiso, al igual que un cerco, igual instalado sin los permisos correspondientes. Al día de hoy, en la mañana de hoy, se checó el sistema, aún no hay aplicación o permisos obtenidos para estas cosas en particular. Entonces, a lo que el magistrado le pregunta a la gente de la ciudad cuál sería la recomendación que ellos estarían dando, por lo que ella recomienda que se proceda con las multas hasta que se esté en cumplimiento.
Ok, yo quería solicitar porque yo con anterioridad habíamos venido, yo había participado en un hearing y ellos me dieron un plazo de 60 días para poder solicitar y yo le estaba explicando que esas ventanas cuando se compró la casa existían y estoy buscando un general contractor para llenar la forma de proceso para la ventana cuya cerca. Y entonces estaba buscando a ver si me podían dar un poco más de tiempo para yo llenar el formulario perteneciente para poder aplicar para el permiso.
Okay, translate that, and then I have ¿Cuándo usted compró la casa?
En diciembre del 2019.
Okay, bueno, entonces ha comprado la casa
con violación, no, pero la violación
hace 3 años casi.
Y la violación yo estuve con usted que hace como 2 meses y usted me dio los 60 días, pero cuando estoy buscando las aplicaciones, porque usted me dijo, búscame un recibo de que eso estaba vigente en esa propiedad y yo estoy tratando de buscar y ella me quiere permitirlo.
Okay, you can go ahead and translate, please.
Okay. So I was previously called into this meeting. So I have participated this before about 2 months ago. So I was told that I will be given 60 days in order to get in complaint. And I was looking for the contract to get information or the receipts to get information because when I initially bought this house, the windows were already there, and the windows were already there without the permits. So there was this interruption by the magistrate, and then they would have a conversation where he mentioned that he bought the house in 2019. And so that he was still looking for the information to fill out the information in the application, and he is requesting more time.
Ms. Barber, when did you say that this case was first cited, and when was the compliance date by?
The case was the initial inspection was December 15th of 2021, and the case was heard
May 19th, 2022.
Yes. When? I'm sorry.
May 19th.
The case was heard in May with an abatement date of August 5th.
In your experience, for the replacement of windows and fences unpermitted, that is the requirement for the permits, was that a viable or a reasonable time for an owner to obtain a contractor and reach compliance?
In my experience, I believe so. Yes. I know that there may be, and the building official may be able to speak to it better, but for after the fact permits, the requirements are a little bit different, but we do have quite a few property owners that have had to get the after the fact permits. And again, this was the notice went out to this property back in December for this violation. So
okay.
I believe they have had time. Yes, sir.
Does the building official have anything that they want to add, if anything?
Before he goes, I would like to translate whatever he has been told up to
right.
now.
Go ahead, translate, and then the building official can speak, and then I'll be ready to rule.
Thank you. Bien, entonces, Muy bueno. Entonces, ahorita voy a traducir esto. Una vez traduciendo esto, el oficial de edificios estará hablando, ¿está bien? Porque después de eso, el magistrado estará cometiendo su decisión.
Veredicto. Ok.
Sí. Muy bien, entonces, la inspección inicial, según la oficial de código Erin Barber, fue diciembre 15 de 2021. Este caso fue escuchado hasta mayo 19 de 2022. El día agosto 5 es el día que se tenía como de cumplimiento.
Correcto.
Y a lo que el magistrado pregunta, para este tipo de situaciones, con lo que respecta a las ventanas y la cerca, si este tiempo que usted se le otorgó era viable o razonable para que usted pudiese obtener al contratista apropiado y obtener los permisos correspondientes. Lo que la secretaria Barber dice es que a su experiencia es que sí, pero una persona que pudiera tener una mejor opinión al respecto sería el señor oficial de edificios. Entonces, ahora es el que va a estar comentando. ¿Ok?
Gracias.
All right. Building official, you may go ahead.
Yes, hi, good morning.
Good morning.
I mean, the only thing I just need to add, they just need to come in to get the permit. We're here. If he's, I don't know, if he's in next door, he can walk over. We can give him all the information that he needs for the permit. So,
Well, Mr. Building Official, what I want to ask you, Mr. Jean, is that period of time that he was given from, let's say, roughly the holidays to August 5th, a reasonable time for the owner to have obtained after the fact permits for the windows and the fence?
yes, that's a reasonable time. That's, I believe, more than enough. And, they can, they should have done that time frame. That's more than enough time.
All right. I'm going to go ahead and rule, or do you want to translate this first, Mr. Interpreter? Because I want to move this along.
I would like to translate, sir. Entonces, lo que comenta primeramente lo que comentó el oficial de los edificios es que la única cosa que se tenía que hacer, si usted estaba pues en el edificio de enseguida ahorita en este momento, usted pudiese pasar al edificio de enseguida para que le pueda proporcionar toda la información necesaria para el permiso. Y lo que el magistrado pregunta era, la pregunta de él principalmente era si el tiempo que se le dio previamente era un periodo justo, razonable para que usted hubiese tramitado su permiso después de los hechos. A lo que el oficial comenta que sí, era más que suficiente el tiempo que se le había otorgado para completar ese procedimiento. Ahora, señor magistrado va a decir su veredicto. Sir.
I find that there is substantial competent evidence in the record, all accepted without objection, and on the testimony to find there is a violation of the code sections as charged, and that violation will result in a fine of $250 a day, effective since the date of abatement was the 5th. It will be effective on August 6th and on each day thereafter until there is correction or cure, and the $100 administrative fee, since there is a violation shown and proven, is also imposed. I'll just add as a point of information, the owner can always request mitigation of the fine afterwards, but they have to come into compliance first before being able to request mitigation. That's it. Thank you.
Muy bien, entonces, entonces el veredicto que estaré dando debido a la evidencia presentada, que estaré aceptando sin objeción, es que se entiende que, o sea, que la evidencia es pues más que evidente. Entonces estaría poniendo una violación, estaría cargando con esa violación, lo que se resolvería en $250 al día, efectivo desde el día de cumplimiento, perdón, desde el día después del día de cumplimiento. En este caso, el día de cumplimiento es 5, el día que se estaría efectuando sería al día agosto 6. Entonces, desde entonces se estarían multando con $250 cada día, además de la multa administrativa de $100. Esto para agregar esta información para usted, señor, sí puede someter estas multas a litigación, pero una vez
no litigación, mitigación, reducir, no
mitigation.
litigación, mitigación, no litigación. Esa palabra es incorrecta.
Gracias. Entonces sí, se puede someter a mitigación, es decir, para que se reduzca el monto de la multa, y después pero solamente si usted ya ha entrado en cumplimiento con lo que con esto.
¿A qué oficina tengo que dirigirme ahora para poder someter eso, hacerle esa?
Ya lo dijo el oficial de la estructura de la ciudad, pero se lo puede decir otra vez.
Okay.
The building official quite clearly said that it's his office that has to be approached about getting the permits. But you may want to repeat that to him.
Okay. Sí, señor, es con el oficial de edificios, el building official, es donde usted estará yendo. Ahorita el oficial lo había comentado que estaba en el edificio enseguida del de usted.
Okay, ¿cómo se llama el oficial? El Mar.
Mare is the name of the officer.
Well, what is the city? He's asking what is the name of the building official where he can process the permits. Can somebody give him that information?
His name is Mark Jean.
Su nombre es Mara Jean.
Okay. Gracias.
Thank you.
Okay. Thank you.
Gracias.
Thank you very much. Thank you all for coming in. We can proceed to the next matter.
We're going to proceed with item number 1 and 2. It is 12605 Apartments LLC, case number CEFOB 2022-00109. This case was found guilty with an abatement date of August 5th. Fine set at $200 and plus cost assessment. Officer is Jonathan Lemestre. And as for item number 2, it is also 12605 Apartments LLC, case number CEVC U2022-00253. Previously found guilty with an abatement date of August 5th. Fine set at $200 plus $100 cost assessment. And we have Andrea and Grada here on behalf of the property.
And while that is appreciated, as is customary, I want to hear from the city first. So let me hear from the code officer now, please.
1 second. Miss Andrea, please raise your right hand.
Yes.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Good morning, Mr. Magistrate. So this case is in regards to BTR and CU. It's a certificate of use in the business tax receipt. As of the final reinspection day of August 5th, the BTR, the property owner has not obtained the business tax receipt or the certificate of use for their property, for their commercial property. I did speak to Andrea Andrada yesterday. She did call me yesterday afternoon, stating that she met with community planning and development, zoning, and she paid the fine, or she paid for the renewal to Isaiah, to our zoning representative. And she's stating that she's waiting for an inspection from zoning, I believe, in order to get the BTR and CU.
So I think the city's testimony, magistrate, is as of our last inspection, there was no compliance. And I believe Ms. Andrada is here to give her testimony in reference to what she's done since the final reinspection date.
Right, and that's fine. I mean, I believe in adjudicating the cases that are on the agenda. If this is on the cusp of the issuance of the BTR or the CU, I query if that's viable to adjudicate today. But I don't know. I can only go by what I hear here. So I don't know.
So I would say she can give her testimony. It sounds like, she told the officer she made a payment in terms of, to try to come current. But I would have preferred that she give the testimony on behalf of what she's done, because again, as of our final inspection, she had not been in compliance.
I understand. Ms. Andrada, you're under oath. What is your relationship to this property?
Good morning. I manage this property since the owners bought the property.
And when was that?
Since
when
they
was,
bought the property.
And when was that? What date was that?
2018.
Okay, go ahead. Go ahead.
Okay. I was deeply into this case because we had a pandemic, and at that time everything was freeze for a year. So I found that we had a previous certificate of use, which is now in record of the city, because the city of North Miami changed their system. So when I went to the office of ICAIAC, they say, you don't have a certificate of use. And I say, yes, I have the original here. So that's why it doesn't appear on the system. So the only thing that what I need is to renew, which is I pay for the whole year, 4 years now, BTR and certificate of use.
You paid for all 4 years because it's an annual. You understand it's an annual thing. It's not.
Correct.
It's not something you get for life or anything. Okay, it's every year. How much
Yeah.
How much did you pay?
800. Let me see. A total of $892.50. And the problem was.
Is that for what? Is that for the BTR and the CU together, or for one? For both, for 4 years.
For both. The thing is, I'm sorry.
Go ahead.
12605. The problem was they don't apply for IIN number, tax ID number itself, because they have another company as a manager. So we have DBPR at that time also, which was renewed every year, but the problem is everything, it was under another member. So when I went to Isaiah, they say, don't show me anything else because I don't want to know who is the member and who was and who is now. So what I have to do is apply for a tax ID number for 12605, which is arrived yesterday, and I ran to the city to pay all this, and I have to I have to modify the DBPR in order to get this document in 12605 Apartment LLC only, without the DBA name on it. So when I have this, I can have a new certificate of use, and a BTR printed. For now, it's in the middle of the process. The BPR told me yesterday that we have to wait for the inspector to come to the property. It's only a change of name, but still they need to come out. So when they come, they're gonna a new DBPR, and then I can submit it to the city of North Miami to get the BTR.
Okay. The BTR and the CU has to be in the name of the company that I believe is shown on the tax record as being the owner. I believe that's correct. All right.
Yeah.
So having it in the name of another company does not comply with the regulations.
No, it was always under 12605 Apartment LLC, was always. The problem was 12605 it was owned by Global Max LLC, which is another LLC. So when we applied in 2018, we submitted with the tax ID of Global Max. If you go to Zambis right now, Global Max, it doesn't exist anymore. It is that company they don't work anymore with that company. So now they have Fuego Nova, which is nowhere. There's nothing with Fuego Nova on it. So I spoke with Isaiah and the other official, and they told me, you know what? Do everything under 12605, no matter what. Don't put anything else. We have to work with this. So what I did is that, talk to the accountant and say, hey, I need the tax ID number for this. If we don't have it, we have to talk to the owners and apply for it. That's it. It's only with that purpose. They never have a tax ID for 12605 because they do taxes under Fuego Nova LLC, and it's a mess.
But you need a tax ID number for the company that's the owner of record under the tax roll, and that's who has to have the BTR and the CU. But per your testimony, I don't want to put words in your mouth, but you have paid the full 4 years, so you're well underway to doing that, right? Yeah, that should happen soon, the BTR and the CU, right?
Yeah, probably in a week more. That's
okay.
It.
So based on the evidence and the testimony, while it is not my preferred practice to do this, I think the most efficient thing is to continue cases 1 and 2. And, if as it seems by the testimony, that the owner has been diligent in having the BTR and the CU issued, and that is done within the next month, the matter should be closed by the city administratively, in my view. And if not, you can reschedule it. But I believe that's doubtful that you're going to reschedule it. So, unless you want an adjudication, which I would be ready to make, I think the most efficient thing is to continue it and give the respondent a month to, it seems that they're 3/4 of the way to getting the BTR and the CU. I can't hear you, madam.
I'm sorry. Do you have the abatement dates before you so that you could use that as a reference?
Yes, I have. The abatement date is 8/5. So,
so the abatement date that you're setting for the reset for her. So what would be your ruling on a future abatement date?
My ruling on a future abatement date would be, yes, I understand. Thank you. My ruling on a future abatement date would be, Miss Andrada, you said within a week you thought you would have these things? Miss Andrada?
They say I have to wait for them to call me to walk around the property to see if everything is the same as before.
Do you have any idea?
Right. License, and then they sent they email
right. But listen, answer my question. Do you think that will be done within a week?
Yeah, that's what they say. 3 or 4 weeks to.
All right. Okay. The new abatement date on applicable to both cases 1 and 2 is September 5th. Okay.
Thank you.
Thank you very much, everybody.
So you have till September 5th to achieve compliance. Okay?
Okay, thank you.
All right.
I'm going to go ahead and proceed with item number 20. We are here in person. It is Bartholomew.
I'm sorry. You're not entirely clear to me. Could you repeat what you were saying?
Can you hear me now?
I can hear you better now. Yes. Go ahead.
No problem. I'm going to go ahead and call item number 20. It is Bartholomew B. Piano, and case number is CERCV 2022-00149, and the officer is Aaron Barber. No, we can't hear you yet, sir.
Ms. Barber, please.
Right, I am so sorry. Your Honor, let me apologize. I got 3 COVID shots, and the last one's made me sick. And I've been staying somewhere else, and I had people come and get the mail to my house, and I never got much mail. And the only thing I got was something on the door, and they picked it up, and it's dated to come here August 18th for the hearing. I don't know what's really, I made a lot of trouble for the city, and this very nice lady, I met her this morning, Miss Barber, and I didn't mean to get her in so much problems, and I hope you don't find me because I'm really not well, and I really didn't know anything really about this until they picked this up on my door. And I've been staying somewhere else because I'm very sick right now. I'm very dizzy. I'm so sorry, Your Honor, and Miss Barbara too. I plead to put myself on the mercy of this court. That's all can you do?
No, I appreciate that. I hope you feel better soon. I'm sure you'll have, in my view, protection from your vaccines. I'm sorry you're undergoing that health experience. That being said, I want you to understand this is not a circuit court. I'm not a court of equity. My role here is whether a violation occurred or not, and if there is a violation, there is a fine. That will be discussed now with the city. The city will also discuss notifying you. The property was posted. You've acknowledged that. That's how you know about this hearing today.
I got someone to take it off the door. You see, I believe
But that's what posting. That posting is putting it on the door or putting it on a sign.
Yes, and what had happened was I didn't get it till way past the right dates, and I wish you don't find me.
Right. And respectfully, I'm very mindful of your situation, but that's not the fault of the city. But we will hear from. Right.
Yes, I'm so sorry. It's not the fault of the city, and I'm giving the city a big problem, Your Honor. I apologize. Please go ahead, Your Honor.
Right. We'll hear from the city first, and then we will hear from you. And before you speak, you will give your name, your address, your relationship to the property, and then you'll speak. But first, we'll hear from the city. Besides your usual testimony, Code Officer Barber, I'd like to just hear that this violation was noticed accordingly. Thank you.
1 second. Sir, can you please raise your right hand? Sir?
Oh, I'm so sorry.
Raise your right hand.
Wait a minute. I'm confused and I'm blurry. Are you Miss Barber? Because I met Miss Barber this morning, but you look different on the television. You have to excuse me.
No, it's okay. I'm not Miss Barber, but I am going to administrate the oath.
Okay,
Miss Barber will speak.
Okay, go ahead. What's the oath, please? I'm so sorry.
Please raise your right hand.
You don't need to apologize any further for anything, sir. Just listen and participate, please.
Yes.
Raise your right hand.
Okay, I'm going to raise both hands. Wait. I'm very dizzy. I'm so sorry. Go ahead.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So
I'm trying my best. Trying my best to be truthful. I'm very dizzy, and you don't look like the person I talked to.
Magistrate, I would be concerned. Sir, if you're not feeling well, I don't know if there's, I don't want you to potentially. If you're dizzy, what you're saying is that you're dizzy and you're foggy. I would, is the officer here? Maybe he needs some assistance.
I met her this morning. Miss Barber Miss Barber, are you here, Miss Barber? Is that you?
Yes, sir.
Magistrate, I don't know if you, what your thoughts are, but if there's a medical concern.
I like Miss Barber to speak so you'll understand, so I don't get a fine and liens because I can't afford. Okay, please do you want to speak, Miss Barber?
Well, yes, I would say, I would say this, if you don't feel able medically, I mean, you came in,
I like Miss Barber to speak because maybe I didn't do something and right because please, can Miss Barber speak? Maybe it would help. Please, can she speak?
Well, wait.
Yes, go ahead, sir.
Yes, listen. My question to you is, do you feel well enough to participate in the proceedings today, or would you prefer to come back here when you're feeling better? Again, I like to move the agenda efficiently, but if there is some reason to continue the matter, a medical reason, I will. Do you feel, sir, well enough to participate today, or would you, due to your health concerns, your dizziness, or whatever, prefer to come back another day?
Well, let me ask you this. Maybe I'll get worse if I come back another day. Maybe I won't be able to speak for myself. How long would it be? Is there an idea? Because I'm getting worse, I think. How long would it be? I'm trying to get this.
Well, listen, look, normally, again, I'm not a physician and I'm not here to advise you in any way, certainly not medically.
Right.
I'm not competent to do that. But if you have the after effects of a vaccine, that usually passes. That's usually
it's been
something
a while, sir. It's been a while since I got worse and worse gradually. It maybe you better let Miss Barber speak to help.
Right, okay, so my question to you is very simply, do you want to go forward with this today, or would you rather it be reset to another time?
I'm afraid that if I do, I might not be able to speak for myself. So let me try now to see what we can do to give some time so I can get this matter cleared up. I can get some help to do what has to be done.
Magistrate, can I say something, please?
Yes, go ahead, Madam Assistant City Attorney.
Good morning, Assistant City Attorney Benny.
How are you? How are you this morning?
1 second, sir. Magistrate, it looks like he is in the city, at City Hall. Is it possible to ask him if he came with somebody?
Excuse me?
Yes. Do you have a driver that brought you here, or a helper?
No.
That's
no,
very. So
no,
how did
no.
you? How
what
did you?
Happened?
Okay,
what
wait.
Happened?
Don't just listen. Listen to what I'm asking you and respond, please. How did you get here? What was your manner of getting here?
I had them help me to the bus, and I got on the bus, and I came here. I got off the bus, and I'm here now alone.
All right, you've answered the question.
Okay. There's no one to help.
What I would suggest next, Your Honor, if he's capable, I would suggest that he give somebody, they can have a power of attorney to come on his behalf for the next hearing, and they can testify on his behalf.
No, I don't want no power of attorney. Please try to get Miss Barber at least to speak, to explain what's wrong, or you want me to explain what happened? Let me explain.
No, you're not going to explain until Miss Barber explains. First, we hear from the city, then we will hear from you. That's the order. That's the general order of things.
Then go ahead and let the city speak. Let the city speak. I'm afraid that I'm not going to be able to speak in the future, right? I'm too worried about this. I want to get it cleared up.
But the city attorney is correct. If for whatever reason an owner is out of the country, is feeling poorly, has a conflict, they can give a power of attorney to someone to come and handle.
I don't want power of attorney. I want to let the city speak, please, and maybe I could.
Okay. All right.
Please.
Okay. Yes, I understand. Thank you, Ms. Barber. Go ahead.
Yes, sir. Aaron Barber, City of North Miami, code compliance. This is a new case in reference to a small cargo trailer and a small camper that are located on the property. There are no variances for either items. The case was the initial inspection was on January 28th of this year, and as of this morning, there has been no compliance. There are no variances. The items have not been removed. And this gentleman has been here in the office since about 8:30 this morning for this hearing.
So, does this gentleman, insofar as you know, in any conversations you've had with him today or otherwise, does he understand the variance procedure that is required to be able to have those things lawfully on the property, Ms. Barber?
I don't know that he is aware of the actual steps to be taken in order to obtain the variance, but we did speak about the variance, obtaining a variance for those items or having the items removed from the property. We did talk about that this morning. Yes, sir.
Okay, and was this case noticed per the code sections and regulations appropriately?
Notices were mailed, certified, and posted at the property as well.
I would also add, Magistrate, that the notice states that there should be a variance in the description.
Yes, sir. I did add that information into my notice along with the phone number for CP&D.
Right. So the bottom line here, so you understand, sir, is that the variance is the permit that you need from the city.
I'm so sorry. Go ahead, Your Honor. I never got any notice until somebody put this on the door. Actually, I had people going over there to pick up the mail. I'm not living there. I'm staying with other people because they don't feel good.
No,
a
and
lot of mail was missing.
Right.
Maybe they did send other things, but a lot of mail was missing. I never got anything but this on the door, and I came
I understand.
I
listen, please calm down and listen before you speak.
Yes, Your
Okay.
Honor.
This is a fairly simple matter. You need a variance permit in order to have the cargo trailer and the camper on your property. You can't do it without a variance permit, which you need to get from the city of North Miami. You either get the variance permit or you remove it. One of the two. So now you'll be able to speak. But first, Ms. Barber, is there anything else you want to add or anything else you want to explain to this gentleman?
No, sir. That concludes my testimony.
What is your recommendation in this regard?
Recommendation would be an adjudication and time to comply. Apparently, as this gentleman has noted, he's not staying at the property. So I don't know what type of help he will have to get the variance or to have the items removed from the property. So I would recommend an adjudication with time to comply.
And in your considering the circumstances, in your professional opinion as a code compliance officer, in light of the facts and in light of the norms for this kind of violation, what would be a reasonable time to comply?
In this case, I might say
case.
60 days, I would think.
And what would be the recommended fine if there's not compliance?
Well, on a first-time violation, Magistrate, you have discretion up to $1,000.
Can I speak now? I don't think I should.
You've heard everything. Please give your. Yeah.
I'm so sorry. Do I have 60 days to comply? You're not going to find me?
Listen, we haven't done an order yet. Please give your name.
I'm so sorry.
Yeah, no, don't apologize again, sir. Please, there's no need.
Yes.
Everything's fine. Just give your name, your address, and then tell us what you want to say about this matter. You've heard what Ms. Barber said.
My last name is Paino, Paino. The address is 1350 Northwest 131 Street, North Miami, Florida, 33167. All right, I'm going to try when I leave here to get on a call around to see if I can get someone to help me, maybe take away these things. That might be the easiest thing to do at this point. I wish this honorable court would not find me or lien me or anything, because I'm very, very hard for me, okay? I put myself in the mercy of this honorable court, and I hope you'll give me the 60 days and don't find me now. Give me time, please. Because I say again, I have not been living there. A lot of mail's been missing. I had people pick up the mail. A lot of things have been missing on me. All right. Please, I got this on the door. Somebody picked it up for me. I'm so sorry. Please, I put myself in the mercy of the city, put myself in the mercy of this honorable court to give me 60 days. Please don't find me. It's very financially hard for me. Please.
Let me ask you something, Mr. Bino. I think we know this, but I just want you to say it. You are the owner of the property, right?
Yes, I am.
Okay. Are you, and just as a point of information, are you currently retired or are you employed still?
No, I'm unemployed. I've been unemployed a long time.
Are you?
No. Yes, go ahead, sir.
Yes. Are you on Social Security and Medicare?
I'm on Social Security. I only get, after they take away the Medicare payment, I only get like $420 a month. It's very, very hard for me. Okay. I'm very dizzy right now. I don't know if I'm saying everything 100% correct.
No, you've been very clear. You've been very clear. Thank you.
Okay, Your Honor. I apologize to the city.
No. Yeah.
And I put myself in a mercy not to find me. Give me the 60 days.
Ms. Barber, I have one technical question. If the owner appears he's decided that he wants to remove the cargo trailer and the camper, is there a permit required for that, or that can just be done and you would reinspect?
That can be done without a permit. They just need to be removed from the property. I would reinspect it, and then he would be in compliance.
Okay. Listen carefully. In light of all the evidence presented and considering all matters in the record, including the photographic and other evidence and testimony, all of which is admitted without objection, I am going to find that there is a violation of the code as charged for having the cargo trailer and the camper on this property without the variance permit that is required. However, I will give the owner, Mr. Bino, 60 days to remove it or to secure the permit. His option to do either one, 60 days to remove the cargo trailer or the camper or to secure the permit. Considering Mr. Bino's circumstances, which I have taken into account, if there is not compliance within 60 days, a daily fine of $100 will be imposed until there is compliance, and the $100 administrative fee does have to be involved and does have to be imposed, Mr. Bino, because there is a violation here of the city code. Sadly, I have no discretion in that matter. The $100 has to be paid because there is a violation. There will not be any other fines or penalties if you remove those things from your house, from your property within 60 days. Am I clear?
I understand. There's no way not to fine me the $100. I must pay that.
No, there is no way. I don't have any. I have no discretion.
I don't have much money, but I'm prepared to make a check right now because I don't want you to put a lien on my property. Can I make a check right now before?
So you're not being liened right now. All you need to do is make your phone calls and move the trailers, if that's what you choose to do. Or you can go next door to our zoning office and apply for what's called a variance so that the vehicles can remain stored on the property. You have two choices. So it's totally up to you, and you have 60 days.
All right, but you're not going to put the $100 fine against my property. You're going to. Well, that's not.
It's a court cost. So you have a court cost.
Okay,
for today's hearing, and that's $100. And once we finish up here, we can talk to you about how to get payment for that.
All right, but I do have to pay the court cost. There's no.
I have no discretion in that. If there's a violation per the laws and regulations, $100 must be imposed. There's no,
All right.
I'm sorry,
All right.
I'm very sorry, but there's no exceptions.
All right, can I pay the $100 now with a check? I don't want to lean. I don't want to lean
Right,
against
we
my
understand,
property.
sir. As soon as we
I
hang
wanna-
up this, sir, as soon as we hang up the call, our staff will talk to you about how to make payment.
Okay, will they accept it here, or do I go City Hall?
We're gonna talk to you about how to accept payment as soon as we hang up your call.
Okay.
One of the young ladies that's right there behind you is going to assist you.
All right. I don't want no liens. Thank you, and no. Thank you very much for your help.
Okay, thank you.
Thank you. Thank you very much for coming in. Thank you all.
Thank you.
Thank you, sir.
I'm gonna go ahead and proceed with item number 30.
Item number 30.
Item number 30, for Green Acre Park LLC, case number CEMIS 2021-00044, and the officer is Jose Perez. And we have Alfredo Gonzalez here on behalf of the state.
All right, let's hear about the case, the nature of the violation, the status of the violation, so forth, etc., from the officer first, and then we'll hear from the respondent or their agent. Thank you.
Who do I have here on behalf of the property? I see Alfredo Gonzalez hand raised.
Yes, hello?
Alrighty, just a moment. I also see a Michael Owens. Are you here on behalf of this property as well? Mr. Gonzalez, is a Michael Owens also here?
Not familiar with that name.
Okay. We can swear him in, clerk.
Mr. Alfredo, are you an attorney?
Yes, ma'am.
Okay, go ahead.
For the record, Alfredo Gonzalez, officer 323 Southeast 2nd Avenue with Greenberg Torg on behalf of Green Acres and the Home Depot.
Officer Perez with the City of North Miami. Today we're hearing the case in regards to the property located at 12055 Biscayne Boulevard. This case is specific to Home Depot. The Home Depot is in violation of the City Ordinance 11-142, and that is because they have not submitted any shopping cart preventative measures to the city, and thus they are not in compliance with that requirement. Additionally, the city has had to collect shopping carts every month, and that is becoming a hindrance on the city, and the city has had to collect consecutively every month many shopping carts from Home Depot, as there will be evidence here to attest to that. At this point in time, I'll request that we could have some of these pictures and email documentations here.
Go right ahead. All evidence is accepted into the record unless there's an objection, and if there is, that will rule on it. Go right ahead and do your narrative about the pictures and your other documents, Mr. Code Compliance Officer.
So here we have some pictures from the motor pool that's over at Public Works. They went ahead and have staff that goes around and picks up the shopping carts. As you can see here, for example, for the month of August, 6 Home Depot shopping carts were collected. Prior to that, there was 4 in July. Prior to that, there was 6 in June, and it goes back and the numbers increase as we go into May. For example, there were 17 shopping carts that were collected, and there's just a list that goes on and on. In essence, the company has failed not only to provide a preventative plan to the city, but preventing any shopping carts to being released into the public, and that is becoming now a nuisance. So at this point in time, the city is seeking for an adjudication as well as for the Plaza and or Home Depot to submit shopping cart preventative measures to the city and abide by those shopping cart preventative measures.
Officer Perez, can you summarize for us, for the record, what the city code requires in terms of those preventative measures? That is, what needs to be submitted and to whom and how often?
Not a problem. So let me defer directly to Chapter 11, and I'll read it verbatim. 1 second.
Okay, administrative notice is taken of Chapter 11. Go ahead.
The ordinance says here, every business and or entity that utilizes shopping carts in its operation shall affix the following notice to all such carts, and such notice shall be clearly legible in English, Creole, Spanish language, and so state. Any person that removes shopping carts from the premises of the owner or its possession of any shopping cart shall be presumed to be in the possession of stolen property and is guilty. And that's pretty much the warning that's supposed to be on the cart. It says, failure to abide by the provisions of subsequent sections shall be constitute a violation and shall result in civil penalties. Additionally, on or before October 1st, 2018, of opening of the business or the initial use of the shopping carts by the business, whichever is later, any business and or entity providing shopping carts for the use of patrons of employees shall construct barriers to prevent removal of shopping carts from the business or premise, or attach an alarm mechanism to the shopping carts to prevent their removal, or implement a policy for not allowing customers to exit the store with shopping carts, and or provide an employee to carry or wheel the customer's merchandise to the customer's vehicle, or implement some other plan approved by a city that will prevent removal of carts from the business premise, and implement a twice weekly program of collection of shopping carts that are illegally removed. An affidavit from the affected business owner detailing the specific days of the collection shall be submitted to the city. Failure to abide by the provisions of the subsection shall constitute a violation and result in a civil penalty. Right. So, with that itself, those are the requirements, and that could be submitted to our offices directly. It would be submitted and reviewed by our office.
To your knowledge, Officer Perez, has Home Depot ever done any of those measures that are required by the regulations?
To my knowledge, no.
The date of compliance for this violation, the date of the abatement date, as you call it.
The original one for this specific violation was January 7, 2022.
And nothing has happened between that date and today to demonstrate or manifest any compliance by Home Depot.
That is correct. At one point in time, representatives from Home Depot did reach out to our office and did ask for an extension. An extension was granted in good faith, assuming that they would have some sort of remediation.
Jose, can you clarify for the magistrate? I'm sorry, the final reinspection date for the hearing, and in terms of dates.
Yeah, that's
Sure.
what I was getting at, actually.
Yeah, the final reinspection date for this hearing was August 5th, 2022.
So taking into account any extensions that you granted, the final reinspection that you did was August 5th, 2022, and there was no compliance with 542, which again I have taken administrative notice of, and as part of the record by that date. Is that correct?
Correct.
Okay, and this may be a somewhat naive question, but how do you know it's a Home Depot cart? Is it because the Home Depot logo is on all those carts?
That is correct.
Okay. They don't use carts that don't have the Home Depot logo on it, right?
As far as I'm aware, they do not. However, here you can see in the picture that was submitted by the Public Works Department, it says the Home Depot.
Okay. And when the city has to collect these carts themselves, briefly, what does the city have to do?
So in essence, any personnel from the city that sees shopping carts has to report it to Public Works, and they have individuals who ride around and pick up these shopping carts. So it's taking from resources from Public Works to have someone go in a pickup truck and pick these up to drop them back off into the motor pool area.
And to your knowledge, is there a way that a commercial establishment can place a device on the shopping cart to keep it from being removed from the premises?
Absolutely. Several stores throughout the city do have shopping carts. This is the only store with shopping carts. Other stores have, for example, locking mechanisms in the wheels. So the shopping carts lock up as soon as they leave a certain area on the perimeter of the property. Some of them have poles that extend over the exit of the storefront so that they won't even leave the store with the shopping carts. There's different measures that they can take in order to prevent this.
Okay, thank you. Is there anything else at this time that you want to say?
The city concludes its presentation.
Okay, Mr. Gonzalez, good morning. Hello. What do you want to say about this case, or what questions do you have?
Good morning, Magistrate. Well, number one, and I apologize because it's not the understanding that I've had from my client. Yes, there's been a problem with the shopping carts being removed off the property by customers and individuals, and my understanding was that they were working with the city. They actually initially, before the violation was issued, they would have their own company come out once a week to do pickups and search around the neighborhood for any straggling shopping carts. That was their policy. At the time the violation was issued, you had several that were months where it was like 25, 26. That led to the violation, which thereafter they contracted to increase their private pickups to 5 to 6 days a week, which they were doing. That's what they've been doing good part of this year, which is reflects the reduction in the collection of carts by the city. It still doesn't resolve the problem. And actually, in that process, Home Depot decided that it still wasn't getting to the level that they realized the city would want to see. So they went out to look for bids to add this locking mechanism that was mentioned before. I can tell you that Home Depot is still doing their collection services privately, but they have worked out with the owner. And actually this week, the owner signed off on allowing the construction, because you have to put a perimeter fence system. And we have a company is called Gatekeeper System, who is being contracted to install that system at the Home Depot in North Miami and store in question. So what we're looking for is to give us another maximum 90 days. We feel that it'll take about 2 weeks for the contractor to move to permits, whatever time it would take to obtain the permits for the work that needs to be done, because it's not just locking mechanism on the car, but it's establishing the perimeter fence, electronic fence around the property. And then the actual work will take about a month to do. So at this point, we will provide contracts, whatever. I'll work with the code officer to provide to the city the affidavits that are needed from the Home Depot of exactly what they're doing. So there's no question that they're in full compliance with 11-142. But they had taken steps prior to this hearing. The steps they realized was not achieving the goal that everybody wanted to see. So I can't speak for who they spoke to, but I was told by the representatives of the Home Depot that they had been in communication with the city, and that's why they increased their collection to try to resolve the problem originally.
And I've heard your facts that you've stated, and it seems that Home Depot is proceeding now in good faith to address this situation. However, militating against that.
I can't hear you. I'm sorry.
Okay. I will repeat it. I'll speak closer to see. It seems that Home Depot is proceeding in good faith to address the situation. However, the fact is that the reason that the code that was accepted into evidence, 11-412 of the city code, was first enacted, I believe, in 2018, and the original abatement date was January 7th, which is 8 months ago, and then we had ultimately the date of August 5th. So I think, considering the fact that it's been a recurring problem, using city resources and perhaps presents an impediment to pedestrian and traffic flow, that Home Depot did not comply with the extensions given within the time given. So I am going to find Home Depot in violation of the code section as cited in the notice and in the hearing date. The fine is going to be imposed, prescribed by the code, of $250 per day. I'm going to make that effective August 6, 2022, which was the day after the final inspection date or the compliance date. I am sure that once Home Depot comes into compliance and the city can confirm that, the fine will end. But as a further encouragement and enticement for Home Depot to do it, I think that enough time has passed with these extensions.
Magistrate, this is
Yes.
a new case. This is a new case.
This is a new case.
You're on. Yes.
Okay, this is a new case, but all right. Well, I think then that it's not a prior violation that they had before that is coming back. Okay, I think that I will give Ms. Officer Perez, let me ask you this. Presuming that Home Depot is underway to cooperating on this, what do you think is a reasonable period of time for them to come into compliance with what's required by Code Section 15-542?
11-142.
11-142.
The city doesn't have any. The city doesn't have any objections to granting them time. However, we do want to advise council to submit plans prior to actually acting on any plans on behalf of Home Depot. They should submit them to be approved by our department. The city does need to have prior approval beforehand. And in regards to the time, I don't necessarily have indicative time set. However, I think Director Patterson did want to have some input there.
Yeah, I just wanted to add the 90 days that he's requesting, Magistrate, we're fine. The city's fine with that. But just to echo what the officer said, if you could submit your preventative measure plan as per code to the city for review, as soon as you can, that would be preferable in this matter. And then, whatever subsequent adjustments or changes the organization intends to make to ensure or to act on the plan, should be done after the plan has been submitted.
And we have no objection to that, Mr. Manager. We'll make sure that we'll get the plan that we're hiring the contractor to install prior to him or simultaneously of applying for a permit, submitted to the department so they can review the plan and sign off on the plan. So we're not seeking permits for something that needs to be modified. But our intent is to, as quickly as we could we already have the contractor ready to go and get the work done. So we'll submit the plan to the city. We'll apply for permits, and we'll continue during this period of time to have the private third-party company who's been going out, making sure they see carts out off the property to collect them, which has been that's why the numbers have gone down. It hasn't zeroed it out, but at least in the interim, until we construct the new system, I didn't want to drop that and let the numbers go up higher in the interim?
No, I mean, I saw that list. I was under a misimpression that there had been a prior violation because some months were 6 or 4, but there was one month I saw that was 17 and it was a greater number of carts. But in any event, based on the testimony and the evidence that has been accepted into the record, I do find that there is a violation of Code Section 11-412, and you will need to come into compliance within 90 days. So the abatement date will be 90 days from this date of hearing. If you are not in compliance, and that means full compliance, submitting the written plan to the city as requested for approval by code enforcement director or public works director, whatever the case is, that how the city approves that, and having the preventative measures in place, all of that is required by 11 -412 has to be done within the 90 days. If not, there will be a $250 per day fine commencing at that time, and the $100 administrative fee is assessed because there was a violation that has been shown to exist past the final inspection date by the evidence. So that will be the ruling on this case. Are there any questions?
No, I fully understand, and we look forward not to have fines accrued on this project.
I think if you comply with what that code section that was read into the record requires, hopefully it will be the case that there will be no fines.
Thank you.
Okay? Thank you. Is there anything else from the city on this?
No, thank you, Your Honor.
All right, thank you very much.
Thank you.
We're going to go ahead and proceed with item number 23.
Item number 23.
23. David Romero and wife Juana, case number CEBPR 2022-00327. This case was previously found guilty with an abatement date of August 5th. Fine set at $250 plus $100 cost assessment. And the officer is Aaron Barber.
If you're here on behalf of this property, can you click the raise hand feature, or do we have a name, clerk?
Sorry, he's here in person.
Okay.
So when you tell me that that case was previously found guilty, this is not a first violation?
No, it's been.
Okay, now that's you. But yeah, please just say that at the beginning. So okay. All right.
Just a moment, magistrate, as we give the person access to the meeting.
Yeah, that's fine. No problem.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Good morning, Aaron Barber, City of North Miami Code Compliance. As noted, this case has been previously adjudicated. The original violation was noted on February 9th of 2022 for the fence that was installed without permits. As of the final recheck date, there was no compliance. And again, as of this morning, I did check the system and I found no applications have been made and no permits have been obtained for this fence.
And what was the earlier reinspection date where you mentioned it, but you didn't say a date? I'm just curious.
The final reinspection date for the hearing was August 5th. As of August 5th, there was no compliance. As of this morning, the 18th, there was no compliance.
And what is your recommendation?
To move forward with the fines until compliance is met.
Excuse me.
And the recommended fine amount for this?
The fine that was set by the magistrate was $250 a day.
Thank you. Is there anything else at this time?
No, sir. That concludes my testimony.
Okay, Mr. Ramiro, let's your name, your address, and then tell us what you want to say, please.
Hey, my name is David Romero. The address is 820 Northwest 123rd Street. I am a parent, but it's me and my wife and my grandkids, and we, trying to pay all the bills and everything on time. I was trying to look for construction contractors. I spoke to a few of them. A few of them went to the house to give me a quote, and all of them are telling me 1,500. One of them told me 1,700. The last one that I spoke to, that he's supposed to go in next week, the 25th, I got 2 people going in, and they coming up with reasonable price. One lady told me 800. The other guy told me 750. And I am trying to comply with it. I'm trying to do the best I can. But it's been difficult due to the fact that I had COVID 3 times, and it was hard for me. I'm trying to fight with catching up with all my bills.
Thank you. I appreciate your candor, your honesty. Ms. Barber, what is the time, in your estimation or in your opinion, or that of the building official, whoever wants to answer, what would be a reasonable period of time to have obtained a fence permit? So all I'm asking you is simply, how long does that take, more or less?
Good morning again, Mayor Jean. Was listening to the case. This is item number 23, right?
Yes.
The gentleman mentioned, so you're trying to get a contractor for the fence?
Yeah, for the fencing, yeah, because the paperwork says that I need a licensed contractor. I mean, the first fence that I put up, I actually put this fence, the wooden fence, up when I moved into this property. I did it myself, and I took out all the permits and everything, but I did not know that to change the material, you have to take out another permit. And this is why I'm in this situation right now. I mean, I didn't put the fence up by being without a permit. The first fence that was put up on this property was due with a permit. As a matter of fact, I had to get permission from every single neighbors that I had. I had to get permission for them before I put up this 6-foot fence.
So what we could do here at the building department, you don't, since you're the owner, right, of the property?
Yes, sir. I am
you can
the
do
owner,
an owner
yes.
builder. Just be cautious of, during inspections, we might ask you to kind of dig so that way we can see how deep the footings are.
Okay, I could do that.
Yeah.
I could reopen it so you can see what I did.
Yeah, but let the after you get the permit, let the inspector instruct you how to move forward with certain things he wants to discover.
Okay,
so
I comply with it.
Builder.
Okay, so I could do it without no constructor.
Yeah, with no contract.
Okay.
Now, if there's issues where the fences needs some enhancement or something like that, then we'll cross that bridge when you get there.
Okay, I appreciate that.
Okay.
Thank you.
Thank you.
And I appreciate that. And Mr. Ramiro, no one's task here is easy. Not the city's, not yours. I understand your arguments and what you've said, but particularly here, when a violation has already been found in the past, I feel that my hands are tied. And this, I'm mindful of all your duties, but this should have been a fairly simple permit to make. I'm sorry that you did not reach out to building before to discuss all this in advance. I'm going to find, based on all the evidence in the record, which is accepted without objection, inclusive of the testimony, that there was a violation of the unpermitted fence as charged per the code as of August 6th, the date after compliance. There will be a $250 per day fine until there is compliance, plus the $100 administrative fee because there is a violation. Mr. Ramiro, I will just add that once you come into compliance, I'm not advising you, but you can ask the city to mitigate or reduce the fine, but you first have to be in compliance. You can't do that until you come into compliance.
Okay,
So that's okay. That's the order.
Yes, sir.
And, I think that unless there's anything else, I think that concludes this particular case.
Thank you.
Yeah. Thank you.
We're gonna go ahead and proceed with item number 19. We have Barry Lapid's Trust and One Bayview Trust. Case number CSTR 2021-0030. We have Officer Cordoba on behalf of the City of North Miami Police Department here to testify on this case. And is there anyone at this current moment present for this?
Ms. St. Louis, is this an initial violation, or was there a prior finding on this?
There's no prior findings. This is a new case.
Is there anyone here on behalf of item number 19 on the agenda, property address 2243 Bayview Lane? Jose, do you know if anyone's here?
I don't recognize any of the names for that case, no.
Okay. Magistrate, because the police officer is here who physically witnessed the short-term rental, though the property owner is not present, we would kindly ask that you would hear the case so that he can get back to his duties.
I'm happy to hear the case as long as someone from staff assures me that it was appropriately noticed, per the regulations. It's, not attributable to the city if the person chooses to appear or not appear. So was the case?
I'll put notice on the record. Notice for today's hearing was sent via certified mail, where the officer can attest to the notice.
So the notice was posted on the property on July 28, 2022, and it was sent via certified mail on July 29, 2022 by the clerk.
Okay. You may proceed. That was my question.
Officer Perez of the City of North Miami. Today we're hearing the case in regards to the property located at 2243 Bayview Lane. This is for a short-term rental violation case where the property was rented on December 3rd, 2021 for approximately 1 week. This is an irreparable case due to the fact, the nature that we cannot take back the rental occurred. And the police was called several times, and here we have testimony as well as police reports from the situation where there was disturbance, and the residents in the surrounding area had to call the police to have them pretty much reduce the noise and the music. And we could have testimony from Officer Cordoba for that, as well as the report as I mentioned. At this point in time, the property owner had previously been cited for advertising for short-term rental, and they had assured me that that was not the case. They had even gone ahead and said that they had rented out the property long-term, and they had provided me a lease for that period of time. Now that lease covered well into December 3rd when this occurred, and the dates there says, for example, September 21 all the way till April 17, 2022. The property owner provided this information. However, the fact that the police department had to respond on December 3rd, and the persons who were staying at the property advised that they were renting it, says otherwise. So in good faith, the code compliance department essentially closed out the previous case for the advertisements. And here we have months later, the property is confirmed to have been short-term rented. At this point in time, I would like to have the testimony from Officer Cordoba as to attest what occurred when he went out and responded.
Right, and that's my particular interest, is to know by an admission against interest or however, I need to know from some testimony how you know that it was a short-term rental and not covered by that long-term lease. That's what I will need to know myself. So go ahead, yeah.
Good morning. I'm Officer Cordoba. As the other officer stated, on December 3rd, 2021, at approximately 2:30 in the morning, we responded to the address 2243 Bayview Lane for cause of loud music as a disturbance. When we approached the residence, we heard music, and Officer Bryant made contact with one of the residents. I believe his name was Mr. Canali. And when he made contact with him, he asked him questions of if he lives there, if he rents there, how long he's staying there, at which point Canali stated that he was renting the property for a short period of time. I believe it was 1 week, with some friends.
That's what Mr. Canali said to him, officer. That's what your records show.
Correct.
Mr. Canali said he was renting it for a week.
Correct. So I made contact with the individual, but I was also there.
Okay. Go ahead.
And
Is there a video?
We had body cams on, yes.
Jose, do you have a video?
Yes, we have the footage.
Okay, you should show that footage.
I'll let Officer Cordoba finish his testimony if he wants to give anything else. Otherwise, I'll show the footage now.
No, that's pretty much it.
Okay, let me pull up the footage one second. My apologies for the delay. I'm having some minor technical difficulties to open it.
That's fine. I mean, I don't think I think the footage would be helpful, but one, the respondents have failed to appear, and two, I believe the testimony is sufficient in my view. So, I mean, the footage would be helpful, but I don't find it vital or indispensable or anything like that. If you can access it.
Okay, yeah, it appears that the link that was provided by the body cam footage coordinator is no longer working, so I'm not able to pull up the footage. So unfortunately, I can't process it right now.
What is the recommended fine for this violation?
So with this being an irreparable, irreversible fine in nature, or violation in nature, the magistrate has the freedom to fine up to $15,000 at your discretion.
Based on the testimony and the evidence, all which is included in the record, without objection, further noting for the record that the respondents have failed to appear despite the matter being noticed, I find that the city has demonstrated by competent substantial evidence that there was a violation of the short-term rental ordinance of the city as charged in the notices of violation and in the hearing notices. And I find that the violation is irreversible in nature. That has been demonstrated as well to my satisfaction. The fine imposed is $7,500. That is $7,500 plus the $100 administrative charge is imposed.
Thank you.
I just want to be sure one thing. I've made the ruling, but you didn't mention it. But there was no other violation of the same nature at this property that you're aware of. I should have asked you that. I mentioned, but
rental itself, no. For advertisements,
okay.
Yes.
Right. No. I meant for the rental itself. This is the only one that
correct
has been brought to. Okay, all right. Then that's the order. Thank you.
Okay. Thank you, Officer Cordoba.
Thank you, officer.
Thank you. Have a nice day.
I'm going to proceed with item number 16. We have AHDS Ocean King LLC, case number CEZCU 2021-00211. The officer is Christopher Colson. This is a first-time case. And as for the person here on behalf of this case, we have Eric Martin.
Mr. Martinez, if you can enable your audio and video. Mr. Martinez, are you there? Eric Martinez, I see you signed in, but I'm not sure if you stepped away, but we may have to skip your case. Okay, there he goes. If you can enable your audio and video, please, sir.
Video? Okay, hello? Video. Salimos. Hello.
Hi, can we swear you in?
Yes.
Please raise your right hand, sir. I can see your right hand.
Raise your right hand.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do. I do.
Good morning, Your Honor. Are we ready to proceed?
Yes.
Good morning. My name is Officer Christopher Colson, City of North Miami Code Compliance. This is a new case, a certificate of use case.
Yes, go ahead.
Okay, the case was opened 11/30/2021. As a final inspection, it still has no CU on file. But
When was the final inspection, officer?
August 8, 2022. But Eric has been in contact with me via email. He did send me an email yesterday, and they have applied for it as of July 29th. I reached out to Isaiah. He's over in our other office who takes care of the CUs and BTRs, and he said they have filed for it, but it has not been issued. As of the final reinspection and as of this morning, it has not been issued. The CU has not been issued yet.
Do you have any professional opinion as to how long the time period would be for that CU to be issued in the city?
So, Special Magistrate, if I may,
Yes.
Code officer's testimony should be limited to what he observed in his final reinspection, and if we could allow the gentleman, Mr. Martinez, to give testimony as to what he's done as a final reinspection and what he was informed by the appropriate department.
Yes, that is fine. That is fine. Yes. Let's hear from it as you have suggested. Yes, let's hear from. Just trying to elicit testimony that is relevant to that. Let's hear from anyone else who. I just want to hear from the building official or whoever, anybody. What period of time, more or less, right?
Well, for your reference, the code officer can attest. The case has been open since November 2021. So I would say that 9 months, 10 months is certainly adequate time to have applied and done whatever he did as of the final reinspection date. But again, he probably can speak better to what he's done as of the final reinspection date.
Oh, Madam Director, that's responsive as to what I was looking for. So that's fine. Go ahead.
Good morning, Magistrate. Yes, we have been working on a previous violation that has been inspected on a permit that has been closed, and the following process is to apply for the CU. There was a previous CU that was applied for and denied because of the violation. Now that the violation has been closed, we are at that step where we can reapply for the CU, and as we've done, and that's basically it. We're ready to get over with this.
When did you reapply for the CU, and did anybody give you an idea as to how long that would be pending?
I don't have an idea of how long it would be. I think that would best be answered by the zoning department. Isaiah has been my contact. I understand that they have a heavy workload, and I'm doing my best to work with them without bugging them too much about it. But I have submitted the CU on August 27th and paid for on August 29th. Or I'm sorry, July 27th and July 29th.
Right, because August hasn't right. What is Officer Colson? What is the recommended or the general fine for not having a CU or BTR? I imagine they're the same.
Fine. we can find the court costs. I have no problem with that. I don't have a problem giving them 30 more days because right now they are in the process, and Isaiah did reach out to, I responded to my email this morning, so I have no problem extending them 30 more days and they get to see because I know they had other circumstances that were dealing with that property that they had to close out. So that did play a factor in them not being able to obtain the CU faster.
The fine, magistrate, is up to $1,000 in your discretion.
This is a business. What kind of business is this?
We rent
apartment building.
Apartment building for low income.
A low income apartment building. That's
low income families live there.
Okay, and that's limited to the management or the rental of one premises, one facility, not multiple facilities, or is it multiple facilities?
It's an apartment building.
Right. But my question is very simply, is it one apartment building or do you manage more than one?
Just this one.
Just this one. Okay. Based on the evidence and the testimony that has been adduced, which is all accepted into the record without objection, I do find that a violation has been shown as charged in the notice and in the hearing notification of not having a certificate of use. Because there's a violation, the $100 fee is assessed today because the violation has been shown as a standard. The respondents will have 30 days to obtain the CU. If they have not obtained the CU within 30 days, there will be a fine, a per diem daily fine of $250 a day until there is compliance. That is until the situation is corrected. And that is what the order will provide. And unless there's any questions, that concludes this case. Thank you.
All right, thank you.
We'll proceed with item number 23 through 26. The property
23,
owner.
23 through 26?
No, 24 through 26.
24 through 26.
The property owner is Ellie Renier and Renee Renier. We have Mr. Renier via Zoom on behalf of this property. All three cases were previously found guilty, and they had an abatement date of August 5th, 2022. Fine set was at $100 plus cost assessment, and the magistrate further ordered to allow the city access into the home to assess the current living situation. And as for item number 24, case number is CEFAW 2021-0036. Item number 25, case number is CEODS 2021-0082. And item number 26, case number is CEWWC 2021-0041. And we have Ellie Renier.
Mr. Renier, are you there? Mr. Renier, are you there? Okay, if you can just enable your audio and video now.
Mr. Renier?
Okay, there he is. All right, so you got to unmute yourself, sir, and turn on your video. All right, Mr. Renier, you want to unmute yourself so we can swear you in?
Raise your right hand, sir.
Yes.
Yes, I'm here.
We can hear you. Please raise your right hand. We can hear you, Rainier. Oh, no. Rainier, can you hear us? You're muted. Can you unmute yourself?
Would he need an interpreter?
No, he shouldn't. Mr. Rainier, you might want to put on your headset. Put on your headset. Put on your headset. Magistrate, I don't know if you. Okay,
When you. Hello?
Yes.
Hello? Yes, can you, let me ask you this for a moment. Do you want to try to get him so he can hear us while, hello?
Yeah, we heard him earlier, but he did something. Now his audio is kind of acting up. I don't know if we want to maybe table it and come back to him at the, once he gets it figured out. Aaron, you want to chat him maybe and let him know we can table his item and let us know when his audio is working.
I'll send him a message now.
Okay, or give him a call or so, and then let's just go to the next case. Once his audio is working, we can come back.
Yes, that's fine.
I'm gonna go ahead and proceed with item number 31. High Hopes Inc. Case number CEODS 2022-0090. This is a first time case, and we have Officer Sanders. And I believe we have Robert Myers and as well as Philip Muscat here on behalf of this case.
Okay, give them access to the meeting. I see a Robert Myers. I don't see Philip Muscat. Robert Myers, are you there? Robert Myers, are you there? So just a reminder to those of you that are here on behalf of an item today, just please, when you hear your case is called, please be ready to go ahead and join the meeting so we can move forward. Myers, if you can enable audio and video.
There's someone breathing into the device, but I don't. Hello?
Sounds like Mr. Rayner has audio now. Mr. Rayner, you're gonna have to wait. Robert Myers, are you here? Are you ready to give testimony?
Yes, I'm here.
Okay, I need you to enable your video, please.
I'm also here. I don't know if you can hear me.
Is Philip?
Yes.
Okay. You also
who is that? I'm sorry.
Yes, can you hear me?
Philip
Yes, we can hear
Muscat
you.
Yes.
is also here on behalf of this.
All right, just a moment. Philip, if you can enable audio and video once you gained access to the meeting.
Stays attendee or? Should I join?
Hello?
Mr. Myers, just a moment.
All right, can you, Robert Myers and Philip Muscat, can you both please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
I do.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a new case for property address 13860 Northwest Northwest 6th Court. This is a violation in reference to outdoor storage that's located at the property. This violation was originally cited January 28th, whereas I've had a conversation with the property owner, the tenant, regarding miscellaneous items that he had stored outside. He stated he had a business tax receipt and that he was allowed to have storage out at the property. After doing some research, spoke with the community planning and development, who advised him the items needed to be removed. We've had many conversations between myself, the property owners, property managers, tenant, as to cleaning up the property and or removing the miscellaneous items. As of the last reinspection on the 5th, some items have been removed, but numerous items still remain at the property.
Is there anything else that you want to add?
Not at this time. I'm sure as the property owner and tenant speak, there might be additional information I might need to give, but at this time, no.
Code compliance officer, how long do you think it would take, if you have an opinion based on past experience, to remove the, let's just say, the debris or the refuse items that are left on the property shown in the pictures?
You know, I really can't say. I mean, it's so much there on the front and the backyard. This violation has been since January, and very little has moved in or just been shuffled around. So
okay.
I would like it to be moved, very quickly. I want to throw out, and I do this usually during hurricane season. These become projectiles as a storm approaches. It needs to get removed before we get any storm approaching, our area. So it may take some time for him to remove it, but I would love a short abatement date to get the ball rolling with getting these items out of there.
Thank you. I appreciate that. All the testimony and all the photographic evidence and the other documentary evidence is accepted into the record without objection. Is there anything else you want to add at this time?
Not at this time.
Okay, let's hear from the respondents, please. Mr. Myers and Mr. Muscat, if applicable. First, your name, your address, your relationship to the property, and then say what you want to say.
My name is Robert Myers. I am the leasee of the property, 13860 Northwest 6th Court, North Miami.
What do you want to say about this matter?
Well, the matter is that I've been here 5 years. I've never had an issue come up regarding this until Philip received, Philip, the landlord, received a notice in the mail back in February. There was no date on the notice except for a date of February 11th to cure the notice. By the time we got around to figuring out what was going on, we were into March. At the time, I was under cancer treatment from January up through April, the end of April, April 29th. The items that are here are items that come and go on a regular basis through the items that come from companies that are being supplied and shipped to, and then they're taken to their locations. Some of the items are items that I'm trying to dispose of without going to a dump and fill up a landfill. In the meantime, all those items have been removed. I was not aware there was a condition on a license that was issued, as far as the city can tell me, back in 2011, that said there was no storage. I'm not quite sure I understand what storage means, because these items don't stay here but for a short time. Other than my tools and tables, I had 3 work tables in the rear of the property, and the items that I'm working on at the time. But neither here or there. All of the items have been removed as of last night. The rear yard is clear. The front yard is clear, with an exception of right now there's one table that has some materials that the roofer is using. There is a new roof being put on the property currently because in June the roof leaked, and which was another delay in my getting to removing items from the yard, and as well as the weather that we've had with the rain. But all items are removed as of now.
Well, I'm sorry about your personal situation. I'm glad you're better. You know, I understand what you're saying, but based on the photographic evidence, which I have noted and taken into the record, there seems to be an extensive amount of debris, of miscellaneous discarded items, frankly, I can't think of any other more genteel term, junk, that appears scattered throughout the front and the back of the property, making it an eyesore, a blight condition, and possibly a public safety and health violation during hurricane season. So I consider the violations to be significant, as shown in the evidence. Who else wants to speak about this? Yes, what do you have to say? Your name, your relationship to the property, and then tell us what you want to say.
Sure. My name is Philip Muscat. I'm the president of High Hopes Incorporated, which is the owner and the landlord of the property. First of all, I'd like to say thank you to the code compliance officer, to you, the magistrate, and all the other city employees for helping keep our city beautiful. I'm a born and raised native here, and I am working constantly trying to fix this problem. I'm aimed to comply. I think we just need a little bit more time. I do want to point out that the address is very significant here. It's 13860 Northwest 6th Court. This is the street that's parallel to I-95. It's a commercial zone. There are no houses nearby. Folks in this area expect there to be commerce going on in industry. So it's not like we're hurting any neighbor by presenting what you call an eyesore, but nonetheless, we are working on clearing it out. A mobile packing container has been ordered, placed on the property, packed. Things have been taken away. We are working to get this done. I do want the magistrate to know that I have expressed to the tenant, Mr. Myers, the seriousness of this to get it done, to the point where I have submitted into the evidence the fact that I have hired a lawyer and did file an eviction, not for lack of payment, but for the necessity of clearing up. So I did submit that evidence online. There has been an eviction lawsuit filed, and Mr. Myers is aware that it's filed, again, not for lack of payment, but because he's got to clean up. Can you see those documents so you can see how serious I'm taking this? They were submitted
Right,
on.
and I'm mindful of that. I don't know if those documents can be shown. I mean, I know what you're saying, uh, and I hope that you could reach a amicable solution. No, that's beyond my scope and province here. That's a matter between you two as private parties. I can say that even if it's a commercial or an industrial zone, things have to be maintained to code and to standards, and you can't have some, for lack of a better word, some Sanford and Son situation, and or that's not, unless that place, unless that location, unless the city tells me that it's licensed, has a BTR, and is operating as a junkyard. Frankly, based on the evidence, that's what it looks like.
Sure.
So,
And I'd like to say, yes, I respect that. As a landlord, as a property owner, I'm explaining simply that I legally cannot go in and move Mr. Myers' personal property without a court order. So I am trying. So that's the reason for filing the lawsuit, so I can get a court order. It will take generally 45 to 60 days. Once I have that writ of possession, I can then go in and remove anything that's left. But before then, I'm barred. It's against the law for me to go in and move a tenant's property without a court order.
I understand.
So if you can give us, we're requesting 45 days to allow the eviction to run its course, and hopefully before then, Mr. Myers will have removed everything. If he hasn't, then I will be authorized to come in and remove it all.
I think that in light of the fact.
I'm sorry, Magistrate. We're unable to hear you. When you lean over, we can't hear you.
Oh, you're speaking to me? All right. Right. Does the city have anything else that they want to say? Because the original violation, code compliance officer, what was the original violation here?
It was originally cited for this violation on January 28th. But I will say, when I don't mind putting on record, when you say the junk and scattered trash around the property, I did actually cite this violation or this property November of last year, and I cited it as junk. Me and Mr. Myers had several conversations, and there was a problem with the verbiage, and he didn't like the wording of junk. So I did close the violation in January and recited it as outdoor storage. When you ask, is there a business tax receipt? He does have a business tax receipt at this property, but it's for a roofing company. It's Miami Roofing Inc. He doesn't have anything, and I spoke to Mr. Myers about that, as in maybe obtaining a business license as a Sanford and Son business, as a
off shop,
whichever shop he decides to name it. But again, only because you posted it and stated it on record, it's Miami Roofing as a business license, and specifically it states no items can be stored outside, including roofing materials, as stated to both the property owner and the tenant. So just please keep this in mind. And I'm not sure Mr. Muscat understood when he threw out the address. Just as he stated, it's along the expressway. On the way to work, traveling back and forth different times throughout the city, you can visibly see this property from the expressway. It looks horrible. It looks horrible it even looks worse from the expressway. It needs to be cleaned up. So please, please, please give a short abatement date, and let's get this stuff removed.
What is your recommendation?
30 days to the bare minimum. We've already given inside, we've given him 2 or 3 extensions with the closing of other violations. This has been going on almost a year. So 30 days to the bare minimum. Per his testimony, he stated it's done already, if I heard him correctly. So I should be able to go out to the property tomorrow and see a lot of stuff removed. So 30 more days, the rest of whatever is there should be definitely removed.
Is there for outdoor debris, if because I imagine that occurs from time to time. I don't know of this magnitude, but for outdoor debris, is there a general fine amount that has been used?
I would like our director to probably, give testimony as stated, but I believe it's up to $1,000 a day because of the magnitude of this. I definitely wouldn't mind the 1,000, but I think it's 1,000 a day until compliance is met.
So it's up to 1,000, magistrate, in your discretion.
If I may, this property is not Stanford and Son, and the license is a Aaron Handyman. It's not Miami Roofing. Miami Roofing is the qualifier for Aaron Handyman. Am I correct, Philip?
That's correct.
Okay, so it's not Miami Roofing. It is Aaron Handyman. And
I don't know how the roofing company is a qualifier for a handyman, but even as a handyman, based on the photographic evidence, which was extensive, there seems to be a very an overabundance of shall we say discarded items in poor condition throughout the property. It is an eyesore, and I so find. The order on this case is going to be that you have 30 days to comply. If you have not complied in 30 days, I think this has been going on for a year now, since the first citation, or we're approaching a year. It's been going on since late last year. So it's been going on.
January 23rd is the date of the notice. I mean,
we want to debate the matter, okay? Last fall, the code compliance officer was kind enough to close the case because of some objection you had to the verbiage, and the case was reopened. So it goes back to last fall. You'll have 30 days to comply. If not, there will be a daily fine of $750 a day until there is compliance, and the $100 fee is hereby imposed, because I think the violation in the notice of violation and in the hearing notice has been stored, it has been proven, and I would encourage you to use all due diligence to rid the property of this, because I do think that it also, during hurricane season in Florida, which lasts for several months, does constitute a safety hazard as well. And with that, I think that unless someone wants to add something, we conclude this case. Thank you.
Thank you.
Thank you.
Thank you.
Item number 34, Local Union 390BU, case number FYBRR 2020000043. This case was previously found guilty with an abatement date of December 14, 2021. Fine set at $250, and the officer is Gary Beswick. We have Joshua Baldrich. Sorry if I'm mispronouncing your name.
Joshua, if you could enable your audio and video, please.
Hi, good morning.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do. Before to continue, Mr. Sivalich, that is my boss. He's not able to make it. He registered. I registered too. My name is Leonel Morales.
Okay. Thank you. We can proceed.
Building Department. This case is for 40-year recertification. A report was submitted, but it was found with some deficiency, and they haven't complied with the deficiency that was found in the initial report that was submitted. So
I am not. I'm sorry. Officer Beswick, I'm not hearing you clearly. You need to speak up.
Can you hear me?
I can hear you somewhat better now. Yes, sir.
Okay. Well, what I'm saying, this case is for 40-year recertification. They submit a report, but the report that was submitted have some deficiency that need to be corrected. As of today, we haven't received a clear report. So at this point, we're basically just seeking the fine to move forward with the fine.
What is the recommended fine for the failure to recertify the building as required by?
Madam Clerk, could you please check if a fine was set?
The fine was set for $250.
So Magistrate, this is item number 34. It was previously found guilty and a fine was set for $250. It was set for abatement date December 14th, 2021.
Okay, sounds good.
All right, thank you for that clarification. So in summation, the building recertification report was deficient and was rejected, and another building certification report has not been submitted, so the building is not recertified.
That's correct.
Okay. Sir, let me hear from you, your relationship to the property, and your name and your address and what you want to say.
My name is Leonel Morales. The address is 12365 West Dixie Highway, North Miami, Florida 33161. I am the keeper of the organization. We submitted the report with the deficiencies. All the deficiencies are already corrected except for the purlins on the back of the building. It's been a very, very difficult to find a company to fix those purlins that they are deteriorated on the back of the building. Almost 3 or 4 companies declined to the project. I don't know if there's not that an expensive work for them, or we just got a company that is called, their name is CTR.com. They are already coming next week in order to take some measures of the purlins that need to be repaired in order for us to move on. What's the last thing or deficiency that needs to be corrected? We submitted a report, as I said, with the deficiencies and paid the fee to the city. It was very, very challenging to find a company in order to fix that. We are that is in the back of the building. That it does not represent any danger. There's not over a sidewalk. I totally understand that we need to comply with this report, and I want to ask the code officer to know if the city can recommend any companies that they know that they can help us to fix that. The officer just said when he saw me to bring me this citation that I should ask the neighbors. That is, we try, but it's, believe me, it's besides the everyday work here at the office, it's been a very, very difficult for us to find that company. Hopefully this last company, Concrete CPR. The contact person is Alberto. We are expecting him next week again to start working on that, and then right after that, our city builders needs to come by and do the final inspection in order to submit the report.
Okay, is there anything else?
No.
Okay. I don't know if the city has a recommended list of structural engineers or engineering firms or something like that.
No, we
but
don't.
Okay, well then the city does not. That's something you have to research in the marketplace.
Okay.
Is there anything, Mr. Building Official, that you want to add?
Yes. Thank you, Mr. Magistrate. If he wants to, I mean, he can drive around in any concrete restoration that he sees. If there's a particular address, he can make a request and we can provide him the documents, and he can chase down whoever engineer that did that work. We can provide that whatever records request, something that he wants to find out, so that way he can try to isolate a structural engineer to do the work, we could do that for him, but you would have to send a request in via email for us to provide him that document.
What is the email in order for me to send a request?
Let me put it right here. Oh, shoot, what's the general one? I'm trying to put it in the general chat. I can't. Let me put it. You can send it to me there, and
I got it. Thank you so much.
Okay.
What is, I have one question. What is the use of this property? What is it? Is it a business? What it?
We are the office for the Teamsters local union. We are a workers union that we represent around 11,000 members. We negotiate the contracts with the employer in order for the employee benefit.
I understand.
Okay. Yeah, no.
Is there anything else? Does anybody have anything else?
I'm sorry, I included on the evidence pictures of the area that is the purlins on the back of the building, just as a reference.
Okay. Based on the evidence that has been accepted into the record and the testimony that we have heard today, the prior finding, which is administratively noted, of an adjudication of guilt with a correction date of 12/14/21, I do find that the city has shown by competent substantial evidence a violation of the lack of the 40-year building recertification. I consider the 40-year building recertification a serious public safety matter, as shown by events in South Florida. And I think it's serious for any building, regardless of its use, but particularly for a residential building. Accordingly, the fine imposed, effective as of, I don't believe any extensions were given after 12/14/21. Effective 12/15/21, there will be a $250 a day fine for failure to have the building recertified, 40-year recertification, plus the $100 administrative fee. Once the owner, the respondent, comes into compliance and the city finds them in compliance, they can request a fine mitigation if warranted. That's the order. Thank you.
Thank you.
Now, at this point, if I may, I would just like to call for a 5 or 10 minute recess. I know, I have a call from a physician. I'm not dying or anything, but I want to take that call. So can we have a 5 or 10 minute recess before
Sure,
we continue? Yes.
Sure, we can resume. We can recess and resume at 12:35.
Yes, thank you. Thank you very much. All right. Over now.
Recording stopped.
Michael Owen, I see that you have your hand raised. How can I help you?
Oh no, Matt did that already. So
Everybody wants this. Yeah.
Hello.
I can hear you, Michael Owens. How can I help you?
Okay. I was just trying to make sure that I didn't miss anything. I actually checked in about 20 minutes after the session started earlier this morning.
Okay, what's the case you're here for? Because I've been asking everyone this morning what case they're here for, and no one have yet to respond in the chat.
Okay, well, that's part of the problem. I wasn't able to respond in chat. For whatever reason, I'm unable. It says chat disabled. Case number is FYBRR 00059, Space Galore LLC.
Give me 1 second, okay?
Officer Beswick is the code officer.
All right, so your item number 43. So your case will be called shortly, okay?
Okay, thank you.
All right, Michael Owens?
Yes.
I have you down, okay? So your case will be called once we resume from our recess.
Okay, thank you.
You're welcome.
For the printer. This was back then because this was some shit
Special Magistrate, are you back? And also, if you're an attendee and you're here for today's meeting, please check your chats as we're reaching out to you to figure out what case you're here on behalf of. So please respond to us in the chat. Wilner, are you there? Rochelle, I think we already responded to you in the chat.
I believe Wilner and Rochelle are together.
Okay. Warren Seidler, what property are you here on behalf of? Dario Heneo, what property are you here on behalf of? Okay, he says 687 Northeast 124th Street. Wilner, what property are you here on behalf of, Wilner? Roger Lopez, what's the address? Can you give us the address for the property, please? Special Magistrate, have you returned? Okay.
Recording in progress.
Oh, you may proceed.
Okay.
I'm gonna go ahead and proceed with item number 43, Space Galore LLC, case number FYBRR 20200059. This case was previously found guilty with an abatement date of December 14th, 2021. Fine was set at $300, and the officer is Gary Beswick. And we have Michael Owens here on behalf of this case.
What's the case number?
43.
Michael Owens, I'm going to give you access into the meeting. Once you've gained access, please enable your audio and video.
Michael, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
I do.
Okay, you may proceed. First the city, and then we will hear from the witness.
Good afternoon, Special Magistrate. This case is for 40-year recertification. A report was submitted to the city which shows some deficiency that needs some correction. As of today, we haven't received a clear report. So at this point, we are seeking to let the fines move forward.
What is the use of this building?
It is both an office building and a warehouse which serves as a CrossFit gym.
Okay, so it's a multi-use building. Is there anything else, Officer Beswick, that you want to add at this time?
No. Well, basically, yes. The initial report that was submitted, the engineer at the time recommend the building to be condemned. Then, for whatever reason, he changed his mind.
He first issued a report recommending demolition of the building, and then issued...
No, not demolition, to condemn the building, basically.
Okay, to condemn the building. Usually when the building is... I'm sorry a minute. I have to take this call. I'm sorry. Yes. Hello. Yes. My apologies. That's the call I needed to. Yes, go ahead. Go ahead with what you're saying.
Yeah, basically, the first report basically said the building was unsafe. And then for whatever reason, the engineer changed that basically and just have some deficiency. But initially, it was deemed to be unsafe.
Okay. Has the city brought an unsafe structures proceeding against this building? I'm just asking.
No. So
okay.
basically,
all right.
Not yet. So basically, at this point, we're just thinking for the fine to move forward, and that would be the next step.
All right. Mr. Owens, your name, your business address, your relationship to the property, then tell us what you want to say.
My name is Michael Owens. I am the son of the owners of Space Galore LLC in the building, and I help them.
You also have you have a lot of reverberation there. You're go ahead.
Okay, my name is Michael Owens, own the building and Space Galore LLC. We did have a long list of some pretty small items to fix from the report that was received last year. When last we spoke to you, we were just a couple of weeks away from getting the entire building painted, which was, I had thought, the last item. My mother had spoken to the engineer after that had happened. I was under the impression that he had already completed another report, but she was also under the impression that we had the lighting issue that he had noted originally on the original report fixed. It turns out he doesn't see enough illumination in the parking lot in the rear of the building. So as of today, I expect we're going to have a contract with an electrician to change out the bulbs, get more lighting in the rear parking lot, which should satisfy his illumination requirements and complete our report. So I'm asking for 30 days. We should have it done sooner than that even.
Based on the testimony and all the evidence I have heard, and taking into account all the evidence of record, the officer's testimony and your testimony, Mr. Owens, I'm going to find that there is a violation here that was shown earlier. There was a prior finding of guilt for the 40-year recertification. That's a very serious item. It's a public safety item, in my view, as shown by events in South Florida. And I'm not in a position here to judge, nor am I going to judge what the defects or deficiencies are in that building. But the fact that it was at one point spoken of as an unsafe structure makes me think that there may be serious issues there or not. Either way, whether there are or not, that's a very serious requirement. I think that enough time has passed since this has been going on since late last year. We're now in August, so I am not inclined to grant any further time. The $300 a day fine that was earlier found to be applicable is hereby imposed effective on December 15th, 2021, and moving forward each day thereafter until there is compliance. The $100 administrative fee is imposed because there is a finding of a violation for not being recertified. And, I would encourage you to get that report done, to have an adequate report done that the city can approve, and to resolve this violation. And if warranted later, you could request mitigation. But that's the order based on what I've heard.
Thank you.
And I thank you. So that concludes this case. What is the next case?
Item number 49, Wilner Feria, case number FYBRR 20190009. This case was also found guilty with an abatement date of December 14th, 2021. Fine set at $250, and the officer is Gary Bezel.
I'm sorry, can you just go ahead. I'm sorry, Magistrate. I'm having a hard time removing the last respondent. Appears to be stuck. I don't know if it's on my end or
Maybe stuck in the digital realm, but we can proceed anyway, can't we?
Okay, there we go. Sorry.
All right.
And we have Dario. Was that next?
No, for Wilner Feria and
Wilner.
I believe Rachel as well.
All right.
Okay, we can go forward with this case if the city's ready.
Rachel, are you the only one that's going to be speaking, or is your father going to be speaking as well?
Rochelle, I'm the only person that's going to be speaking.
Okay, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Good afternoon, Gary Beswick for the city of North Miami. This one been going on for a long time, but I have a question for the young lady.
How long has it been going on?
This one is due from 2019, but the property was vacant under construction. So I'm going to find out if the property from the young lady, the property is still under renovation. That's to you.
Yes, the property is still under renovation. I'm sorry.
Yeah, the question is for you. Is the property still under renovation?
Yes, the property still is under renovation. We actually had to resubmit plans because there were some things that needed to be changed when we had called for inspection. We actually just got it back. Everything seemed to be okay except for mechanical. So I have them working on that so we can make sure that everything goes good. But we are almost there. It's just that we're just waiting at this point for.
Is it still vacant?
It is still vacant. Yes, it is. It is still vacant.
Okay, Special Magistrate, but based on the fact that the property is still under construction and is vacant, we can go ahead and table this one.
All right. Based on the recommendation of the city, and I'm presuming that there's no objection from the owner's representative, Ms. Perotti, we're going to table this particular item to be rescheduled by the city as they see warranted for a later date.
Thank you.
Magistrate, I'm not sure. Did you want to give us an abatement date on this? Because I think we need to put that in the or we're tabling it.
Well, the code officer, as I understood him, and please correct me if I'm wrong before you leave, Ms. Brody, since we're all here and I believe in having a clean record, I believe that he recommended to me that I table it, which meant that
vacant and under construction, yes.
Right. So which is fine. We just want to how long are we going to table the item for is kind of the question.
Well, as long as this under renovation and it's still not occupied, in my opinion, is fine.
Well, while we're on that, Ms. Perotti, then let me ask you this, because this goes back to 2019, and I understand sometimes that large projects or what they call phase projects can take years. We've all experienced that when they're anyway. But on this project, why this is now 3 years after? When will there be substantial completion of the structure on this project? When is this going to be done? Well, based on your understanding.
Once the mechanical is approved, we don't really have much to be done. So I'd say maybe like another 3-4 months. I mean, it's not up to me. Like, honestly, I've had contractor after contractor. I've lost lots of money, throughout this whole process trying to get it done. I want it done just as much as, I don't want to be in court, behind this. We want to do the 40-year certification, but it's not up to me. Every contract I have, no one wants to work. We were stuck in the middle of a pandemic as well. People that were working were getting sick. It was just so much. So,
but you've represented under oath that the property is not occupied, is vacant.
It is not occupied. It has not been occupied.
And it's going to remain vacant until this is all resolved.
It is going to, absolutely, 100%.
So, Madam Director, what would you recommend that I do then? Because the officer seems just right.
Let's do whatever the 90-day pullout is from that point. And Gary, at that point, we need to go. I think we should go ahead and move forward. I mean, the case has been sitting. I understand the circumstances, but the expenditures to the city to continue to hear the item year after year, we need to probably move forward. So we can do maybe 90 more days, but the next time it's brought before the magistrate, it needs to be, Rochelle. So please do put forth your best effort to do whatever you need to do to get things where it needs to be so that the final inspection can be done.
Okay, will do. Thank you.
Well, there will be. So you're asking for an order then? Because
no, it's not an order. We're I'm just directing staff to put it back on calendar in 90 days.
So for the record, the staff has been directed by to place this back on the agenda. It's tabled for 90 days and will be placed on the agenda again on or about 90 days from now for further resolution. I guess that's it. Thank you. All right. Is that clear to you, Ms. Periotti, before you leave? You're still there. I just
So
want to be
basically
sure.
what you're saying, I am still here. So you're saying that you guys are giving me 90 days to complete the project. Is that what you're saying?
In 90 days, this will be heard again, and then the magistrate is either going to find that there's a violation, and there might be what would be, if there's a violation, a fine and a cost, or some other order will be entered. But yes, in 90 days, some action will be taken.
And you can't give me more than 90 days because, like I said, like we literally just got the plans back from the city. We have to fix the mechanical portion before I can get the contractors to come back out and do what they need to. Can you give me a little bit more than 90 days or no?
Well, I would be inclined to give you more than 90 days, but this matter has been pending since 2019, so I understand the director's point. I think that in light of 2019,
well,
2019, and we're now
we were at a hold.
Right. I mean, and so unless I think that under the circumstances of the 3-year time span, that the 90 days is reasonable. So to me, that is, under the circumstances of the time frame of this case, that is a reasonable time period, in my view. So it's 90 days unless the city wants to enlarge it further. I think it's 90 days. Again, the case has been going on since 2019.
And how do we find out if the city can enlarge it further? I'm just trying to make sure that
No, and you're not. The city's not going to enlarge it further unless it's announced right now. It's 90 days. Right now, it is 90 days.
Okay.
So do what you need to do, what you can, Rochelle, to move your project forward. And in 90 days, we'll reassess, and hopefully you've made some progress from where you are today on the mechanical issues. But, we need to hold you and your father, whomever, accountable to getting this resolved. So as opposed to just having an indefinite date, we're going to revisit the matter in 90 days, and hopefully you have new testimony to give beyond what you gave today.
Okay.
All right. Have a good day.
All right, thank you.
Thank you. Thank you all. Thank you. All right. That concludes this matter.
All right, item number 28 and 29, we have Dario Haneo. Case number, property is GHG on 135 LLC. Case number is CEFOB 2021-0038. It was previously found guilty with an abatement date of June 3rd, 2022. Fine set at $500 plus $100 cost assessment. The officer is Shanna Sanders. And as for item number 29, it is also for GHG on 135 LLC. Case number CEZCU 2021-00178. Previously found guilty with an abatement date of June 3rd, 2022. Fine set at $500 plus $100 cost assessment.
Okay, so let's expeditiously hear about each matter from the involved code officer and then from the representative of the owner.
Sir, please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth, so help you God? Please say I do.
I do.
Shanna Sanders, City of North Miami Code Compliance Officer. This is a case for report of previous compliance. It has already been heard and adjudicated for property address 2345 Northeast 135 Street for not having the certificate of use or the business tax receipt. As of my last reinspection, neither document and or certificate has been obtained. So I would like to move forward with the fines.
And when was that last reinspection, Officer Sanders?
My last reinspection was in this uniform. I believe it was the 8th. Wait a minute, let me look here. I'm apologizing. I show here the 5th. I'm sorry, August 5th. The property is re-inspected and the vibration remains. Proceed with case. Yes, I'm sorry. August 5th of 2022.
Is there anything else you want to add at this time?
Not at this time.
Okay, Mr. Henao, please give your name, your business address, relationship to the property, and tell us what you want to say.
Thank you, Your Honor. My name is Dario Henao, and I represent the owner, regarding this matter. So pretty much, just to make a quick correction here, the BTR was filed, approved by the city. We have received it by mail, and I immediately forwarded that to the inspectors. So the BTR is already approved and done. Now, what we have been doing in the meantime is correcting all of the violations that the building had, which we are physically in compliance, and also we have sent the proof of compliance to the inspectors involved. Now, right now, as far as I know, there's no violations in the building. And the next step, now that all of the violations have been complied with, now we can move forward to the request for inspection for the 40-year certification.
Well, again, what I heard from the officer was the two violations here were not, unless, please correct me if I misheard, I didn't hear 40-year recertification. I heard
I'm sorry,
no
CU, for the CU.
Yeah, no BTR and no CU.
The BTR has already been completed.
All right, so I need someone in the city to check the record, if they can, please, to tell me if the BTR has been issued or not. I need to know that now before I adjudicate the case on the BTR.
What I'm showing here, I don't show any business tax receipt or certificate of uses for GHG.
Sir, do you have the document? If it's been issued, you should have it.
Yes, I have it. I can find it here and send it over. I mean, but I'm sorry. Like, this has been an ongoing problem with the city. You know, the fact that
show it on the screen. Show it on the screen.
I mean, I have to find it. Give me one.
Yeah,
second.
you need to find it and show it on the screen.
Give me 1 second.
If you're saying it has been issued, you should have it at your fingertips, sir, actually, okay? That's what we're here on today.
I'm even showing why he's going through those paperwork. I'm even looking at email correspondence between myself, Isaiah from Community Planning and Development, Raphael Padron from Business Tax Receipt, as well as Mr. Dario. And this is dated the 14th of last month, whereas I sent an email asking, had the business tax receipt been obtained, because I had a conversation with Mr. Dario, who stated he had obtained it, and I specifically said, I just spoke with Mr. Dario, who a representative from 2395 via telephone call, who stated, again, that it's been obtained. Per our conversation, he stated that whatever. Long story short, they responded back to me within 3 minutes. I do not recall speaking to Mr. Dario. They have several violations open at this property. Until those violations are taken care of and are closed, the CU and business tax receipt will not be issued. And this again was from, and you're on the email, Dario.
Yeah, I have it. I have it here. I'm just having a hard time sharing the screen.
Well, you're gonna, I'm gonna make an analogy to what in a court case they call the defense of payment. If someone owes a debt on a note and they say that they've paid it,
maybe can you see it here? Like
what it seems though he's showing what he sent me before, and I've already spoke with him as well as Priscilla and I'm showing here several people, Freddie, Priscilla. They keep showing me the license from the county. That's a Dade County license that they have. They have been instructed by myself and the staff from community planning. They need a business license from the city of North Miami.
So, for example, let me give you another analogy so you understand before I rule, Mr. Hanau. If you are a business, let's just say you are a merchant, you're a vendor, and you're involved in sales of vehicles, and you're operating in the city of Homestead. You need a license from the county, but you also need a license from Homestead. If you're operating a business in Miami, within the city limits of Miami, you need a license from the county and one from the city of Miami. So the fact that you have an occupational license from the county, which I'm not going to comment on whether you need that or not, but you're located in the city. When you're located in the city, you need the licensing from the city. So what he's showing then is a Dade County occupational license. That's irrelevant for this charge. So based on the testimony, Mr. Pinal, do you have anything else you want to say or add?
The only thing and I ask for I just need one day just so I can physically go to the city and bring my paperwork and just have the departments communicate with each other. If you allow me to have one day, I'm recovering from pneumonia right now, and I just
Well,
I just want one day before we start the fines, so I can I can take with me the proper documentation to the city, which was issued by the city and we received from the city. I'm just having a hard time locating it, but we are ready to go. We have taken care of.
Okay. I'm not going to find your testimony incredulous, but I am going to accept the city's testimony over yours. You have shown no evidence of having a BTR or a CU. It is incumbent upon you, sir, if that is your defense, to show it. Not for me to find it, not for me to fabricate it. So I'm not saying you are committing any kind of falsity, but I'm just saying I don't find your testimony credible in light of the city's testimony. In light of the evidence,
We can't hear you, Magistrate.
in light of the evidence and the testimony of record that I have heard, I find that the city has shown that the business tax receipt has not been secured within the time required, and within the time required was the Officer Sanders. Be very clear on this. What was the correction date or the abatement date for each of these things?
I don't mind stating it, but in past we usually have our coordinator state when on the record.
Right. Well, let's have the coordinator, whoever needs to state it.
Unless you don't have it on hand, I have June 3rd, 2022. But
that is correct. June 3rd, 2022 was the abatement date.
For each of them, right?
That is correct.
Okay. Based on the testimony and the evidence that has been adduced and which is a record, which is all accepted without objection, and having considered all the testimony, notably that of the code enforcement officer, I am going to find that GHG 135 LLC does not have a BTR as required, as charged by the violation, the code, and the notice of hearing, and a fine is hereby imposed of $500 per day, effective on June 4th, 2022, and moving forward each day until there is compliance, plus the $100 standard fee for any time there is a violation. On the separate case, I'm going to find that CHG 135 LLC does not have a certificate of use as required by the applicable regulations and as charged in the notice of violation and in the notice of hearing, and as shown by the evidence here today. And a separate fine of $500 a day is imposed commencing June 4th, 2022, until there is compliance achieved, that is, until they have the CU in one case and the BTR in the other case from the city of North Miami, of course, and the $100 fee is additionally imposed in the second case because there's a violation there as well. That will conclude this matter. If there's anything else on the matter, please say it now. If not, that concludes this matter. And I thank you all for coming in.
Thank you, Your Honor.
All right, that disposes of this case. Let's go on to the next case.
Item number 38,
Yes.
NAAI Properties and Management LLC, case number CEBTR 2021-00226. They were previously found guilty with an abatement date of June 3rd, 2022. Fine was set at $300 plus $100 cost assessment, and the officer is Jonathan Lemestre.
And we have Warren Seidler here, right?
Yes.
Okay.
Okay, let's hear from Code Officer Lemestre first, and then we will hear from the warrant individual who's here.
Okay, Mr. Seidler, if you can enable audio and video so we can swear you in.
Can you hear me okay? Yes, we can. Can you please raise your right hand? Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do. I do.
Good afternoon, Mr. Magistrate. This case is involving interior work being done on the property without a permit on file. As of this morning, as of today, there is no permit on file for the construction work done at the property. The case was opened back up. The case was opened on December 22nd, 2021. And I have been in close contact with Warren. He has advised me that he's been working with the building department to get the permits. But again, as of today, nothing's on file for the permit.
And just for the record, in brief, what was the nature of that interior work?
New doors, new windows, electrical work being done on the property, new camera system being installed on the property. Basically, all interior work, windows, doors.
Okay. All evidence is accepted into the record without objection. And I see the different iterations of different aspects of the work that you're showing here by the photos, which shows the unpermitted work, correct?
Yes. Yes, Mr. Yes. Yes.
Okay. Is there anything else you care to add?
No, sir.
Okay. Mr. Seidler, please give your name, your business address, your relationship to the property, and then tell us what you want to say about this, please.
Okay, my name is Warren Seidler. Business address is 687 Northeast 124th Street. I am operations manager for the property owner, NAI Properties and Management. We did file a after the fact permit with the building department. However, they've repeatedly turned down the requests asking for additional information. The latest thing that they had asked for were test reports back from the window manufacturers, which was provided to them. Actually, last night I forwarded a text to Officer Lemastre with the actual screen update that shows that we did update all of these files to the city yesterday. We are waiting for them to respond from the building department if they have approved the permits yet, but we have submitted for all the permits.
Well, yeah, submission is not granting, and submitting the information the day before the hearing is not optimal timing, but I commend you for trying to get the matter in hand. Is there anything else that
just that
it seems to me like extensive work was done without the permit. So is there anything else that you want to say or that the code officer wants to say about this?
Just like I said, just that we have been repeatedly going back and forth with the building department. They would tell us that they wanted one thing, we would do it. Then they would say they wanted something else, we would do it. And we've been going back and forth with them. If you look at the permit history, you'll see there's been a constant update of submissions going back and forth with them, trying to get this resolved. I've been there 3 times in person myself to try to address this with them, but there's always some additional thing that they've asked for, which again, last night we provided again. But we have been actively trying to resolve this.
No, and I appreciate that. And the serial permit comments from public building departments is something you're not the first person to bring that up, but that's, there's nothing I can do about that. Is there anything else from anyone about this? Okay. Based on the testimony that I have heard, I'm sorry, Officer Lemastre, I know that you said that there was a reinspection and that you looked today and no permits had been issued, but what was the original abatement date for this?
The original, well, the final reinspection date was August 5th, and
was August 5th. Okay, all right, all right.
June 3rd.
I'm sorry, I apologize. It's June 3rd, 2022.
That's the date I was seeking. Based on the testimony and the evidence that I have heard and the photographic evidence all being admitted into the record without objection, having considered all of that, I do find that the city has shown by competent substantial evidence that there was various items of unpermitted work done on the premises. Accordingly, I find per the prior adjudication that a $200 per day fine is due commencing the date after this matter had to be abated or corrected, which would be June 4th, 2022, and on each day thereafter, plus the $100 admin fee because a violation has been shown. And once compliance is achieved, the fine will cease and may even perhaps be mitigated in the future. But you know, I think again the evidence showed extensive interior work done without a permit. So the fine will be as stated from June 4th each day moving forward until there is correction. Thank you all for coming in, and that concludes this case.
Magistrate, you said 200, but the actual fine is 300 per day.
Yes, I said 200 per day moving forward. I believe I said that. All right. So unless I'm hearing things, I think I said 200 per day moving forward.
No, the original fine was set at 300. So moving forward.
Oh, was okay. I did mishear you. I am sorry. I apologize. I thought I heard. I have to take the wax out of my ears. I thought I heard 200. If it's 300 that was set, please let the record be corrected. And I meant the fine that was originally set. I thought I heard 200. But if it's 300, yes, it's 300 per day, per diem, moving forward from June 4th, 2022 until there is correction or compliance achieved, plus a $100 admin fee. It is so ordered. Thank you for pointing that out. I misheard
you. You're welcome. No problem. I'm going to go ahead and call item number 37. We have Roger Lopez here for it. Mazal Investment 31 LLC. Case number CEMHS 2022-00293. This case was previously found guilty with an abatement date of August 5th, 2022. Fine set at $350 plus $100 cost assessment.
$350.
Yes, right. And the officer is Christopher Colson.
Good afternoon.
Roger Lopez, I'm sending you an invitation to join the meeting, sir, if you can accept the invite.
Okay. That was it.
Sharina Quinn, your case is next. I'm going to lower your hand.
Can you see me now?
I sure can.
Okay, beautiful.
Well, you can proceed, though. I don't see Mr. Okay, yes.
Roger, please raise your right hand.
Raise your right hand, Mr. Lopez.
Thank you.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God, please say I do.
I do.
Good afternoon again. Officer Colson, City of North Miami Code Compliance. This case involves painting, stucco, and restoration of a building. Maintenance work. It was previously, but the case was open 2/24/22. It was previously found guilty on 6/2/2022. As a final reinspection, the violation still remains. The building has still yet to be painted. That's the testimony of the officer.
Is there anything else you care to add at this time?
No, I don't.
Okay. If there's no one else from the city that has anything to add, Mr. Lopez, your name, your business address, your relationship to the property, and Yes, I'm looking at the photographic evidence. You can roll through that, please. Roll through that.
Chris, if you want to give any description for your photos, now would be the time.
Yes, there's no time like the present.
The description is the stucco work, and they have done some stucco work into the mezzanine and to the building. As you can see, they've been plastering in some cracks and stuff, but they have yet the part of the description is it needs to be painted. So what remains is the painting has to be done, and don't know what's going on with the painting. I'm waiting to hear from the owners to see why the building has yet to be painted.
All right. The photographic evidence is all admitted into the record without objection. It is noted the condition of the exterior walls and the stucco work as depicted on the photographic evidence. Is there anything else?
Not at this time from the city.
All right. Again, Mr. Lopez, as I said, name, business address, relation to the property. Tell us what you want to say.
Roger Lopez, manager, Masal Investments 31, property address 14225 Northeast 6th Avenue, North Miami, Florida 33161.
And do you care to state anything, or do you?
Absolutely, no, thank you, Your Honor. So I agree with everything the officer said. We'll go further to say that the building had multiple violations in excess of 40. Have worked with many of the inspectors to include Ms. Willis, Colson, and whatnot. The only remaining violation is painting on the building, which was we removed the mansard, we weatherized the building, we got all the cracks that you can see, blah blah. We had an issue with the contractor, which has delayed the work. We finally let me go back a little further. The last hearing I was not unable to attend because I had an accident. I had to get neck surgery. Been going through some MRIs and CT scans and all that good stuff.
I understand.
Contracted COVID and whatnot, so I have not been in contact with Inspector Colson to give him an update to the progress of the building. Anna, the property manager on site here, was the one that was doing the contacting with him. She's no longer with us, unfortunately, so I'm picking up the basically where we left off. We did finalize a contract about a month and a half ago with Seppi Painting to go ahead and paint the building. They were running 3 weeks behind. My understanding is that work, which they already started somewhat pressure cleaning the parking lot and whatnot, work will commence next week, and they anticipate that within 30 days, obviously weather permitting, that we'll have it completely done within 30 days. And if you can see, and I didn't submit this, we've been working with this. This is a rendition that we did, even, I don't know if you can see it, this 2021. And that's all building. This is how the building should be looking once it's done. Again, that work should commence next week, anticipated to be done within 30 days, or 30 days from there. So I kindly request that an extension of 30 days be granted, and then we can show that. I mean, it's a 4-story building, so I'm sure it's going to be visible that work is being done on the property starting next week.
Officer Colson, when was the original date of abatement or correction?
Date August 5th. I mean, June 30th. June
30th. Yes.
I think it's June 3rd, right?
June 3rd. I'm looking at it. June 3rd.
Right, June 3rd. June 3rd has been another date, but you know, what do I know? So,
if I may, the city would be okay with giving the property some additional time to cure. I want to remind Mr. Lopez or inform him in case he's not aware. You're going to need a permit to paint that commercial building.
We do have a permit.
You already have it.
Yeah,
okay,
we have a permit. We'll pull the permit again. the issue with the painter, we went ahead and pulled a permit for removing the fascia, stalk of the walls, all that stuff includes the painting there. I can give you the permit number if you like.
So seeing as he's, coming in today in good faith, it sounds like he was in contact with the officer previously and we lost contact for whatever reason. He has the permit. It sounds like he's pretty much secured the vendor to do the work. Magistrate, if we could table the item for 30 days and revisit and see where things land in 30 days.
That is your request, as opposed to having me give a shall we say a mandatory abatement date now?
Because I mean the order, the adjudication has already been entered. So at this point, the next step would be to impose the fine. But I think it appears as though they should be done before our next hearing. I'm hoping so. We would be okay with having tabling at 30.
Okay, based on the request of the city and presuming the concurrence of Mr. Lopez, not that it's needed, but since I'm presuming your concurrence since you requested something along those lines, the matter is hereby tabled for a period of 30 days, and then it will be reset to be taken up before a magistrate by the city at that time, as is warranted. Hopefully, Mr. Lopez, if you resolve everything expeditiously within that time and have a reinspection, you may bring a satisfactory closure to the matter if you can accomplish that.
That is my hope. I will reach out to Inspector Colson and I will give him a progress report on a weekly basis or so, just let him know where we're at.
All right. I think that unless there's anything else, that would, for the moment, conclude this particular matter.
Appreciate it. Thank you so much.
Thank you all.
Item number 42, we have Sharina Quinn, case number CEMIS 2022-0055, and the officer is John Philemestri.
And as to the nature of the violation, in St. Louis? Okay. Yes, thank you. And yes, you may proceed.
Ms. Quinn, are you there?
Ms. Quinn is on the upper right, but yes, thank you for raising your hand. You need to be sworn in, I think.
I do apologize.
No, you don't. No need to apologize.
Please raise your right hand, miss. Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, nothing but the truth, so help you God, please I do?
Yes, I do.
Good afternoon, Mr. Magistrate. This case is being heard for the first time. The property address is 12125 Northeast 7th Avenue. This is in regards to unsafe structure. On April 20th, 2022, there was a house fire at the property, and myself and the lead code officer went to the property and opened a notice of violation in regards to coordinating with the City of North Miami Building Department to bring the property up to code. As you could tell by the pictures, there was extensive damage to the property. As of the reinspection day on May 26th, nothing was done. Nothing was submitted to the building department in order to bring the building back to code. They have, of course, boarded up the windows, cleaned up the debris, but in regards to the roof, the ceiling, nothing has been done. As of August 5th, 2022, my final reinspection day, as you can see, they have boarded up the windows. But again, in regards to the roof, nothing has been done in regards to repairing and obtaining permits.
Officer Lemaitre, I think I know the answer to this, but for the record, when you were at the property subsequent to the fire or for your final reinspection, did the property seem occupied to you?
No, it's nobody's living there at the property. I believe the building department as well, they went to the property and issued an unsafe structure, as you can tell by the yellow sticker on the picture. No, nobody's living there, sir.
Okay. So a determination will be made by a structural engineer, another engineer, the building official, whether this under the 50%, whatever, without getting into the weeds on that, whether this is either salvageable or whether it needs to be treated as an unsafe structure. Yes, or at some
Yes,
point?
the building department would make that decision, or the building official.
They haven't, the building official who may be here has not made that decision yet.
Well, with regard to, and the building official is here, magistrate, what we're bringing today is simply the unsafe provision under city code, deeming the property unsafe based on the building official's observation on, back, I guess, in April when he originally went to the property. I think that there would be a subsequent hearing if necessary or if deemed necessary by the magistrate down at the county. I think because there's no one occupying the space, we haven't found it necessary to go and, through that process, but we're just seeking an adjudication on behalf of city code, which recognizes that the property is currently unsafe in its current status.
Okay, and so thank you for that clarification. You don't have a city unsafe structures panel, you use the county. Okay, fine. I just didn't. So, all right. Thank you, Madam Director. Miss Quinn, your name, your relationship to the property, your address, and then tell us what you want to say.
Yes, sir. Yes, Your Honor. My name is Sharina Quinn.
Yeah.
My name is Sharina Quinn. My property address is 12125 Northeast 7th Avenue, North Miami 33161. I am the property owner, and I can just say that, yes, sir, there was a fire on one side on that. I apologize.
That was some leakage from somewhere else. Go ahead. I don't know who. Go ahead, Ms. Quinn.
Okay, and since then, no one has been in.
I'm afraid you've frozen.
For the $20,000 I needed to pay an art. So the property did go up for sale. I have had an offer or two. The first offer, the property was supposed to close on the 16th of August, hence why I didn't go for it. They actually went to the city to find out what can be done there because they wanted to build more on it. So I didn't do anything because I've been trying to sell it. And as of now, I have a second contract that's supposed to be August 30th. So of course, that was my intention is to try to sell it. I've had nobody there. I've kept it in the best shape possible. It looks, I've had gardeners, I've had everything look perfect, not a piece of anything on the outside looks bad. On one side there was a fire, it was cleaned out completely. Everything was removed, it's gutted out. Just sitting there waiting to be sold, sir. I just don't have the money to put into it that I need to.
No, that's appreciated, and your maintenance of the property under those lamentable conditions is appreciated. So your intentions are to sell the property,
yes, sir.
Not to make a homeowner's claim or have it restored or anything like that.
Nothing, sir. Need to not. I don't have the money to fix it.
Yes,
so
I understand. No, you mentioned that.
It's really to sell it. Sorry, it's been on the market with her Berkshire Hathaway as of June 1st. Was some interest twice builders build because I'm now being told that you could build up and
you're having audio video difficulties, right? You may be in a all right. Yes, there's you look. I'm not an IT. I don't know how to. But you're obviously having some difficulties with your system. Can anything be done to try to get Miss Quinn back in
No,
communicate?
perhaps you have a better area in your home maybe where you can go and get more steady service. It just seems like your service is spotty.
I am actually sitting right next to the Wi-Fi to make sure.
We can hear you now.
Better?
Yes, you may want to get really sort of, right next to the Wi-Fi because you've had.
What can I say?
Yes, I don't know. I understand. Well, let me ask the city this, and I hope you can hear us, Ms. Quinn. I appreciate your honesty. This is not the kind of case that at least this magistrate has heard on a routine, a casualty case of this nature with a fire. So what is the city's recommendation in this respect? Because there's been a casualty and the homeowner has testified that they are economically unable to restore the property and they're selling it. So what is the city's recommendation in this case? This is not at least to me, it's not a day-to-day kind of scenario.
Are you currently under contract?
Yes, ma'am. I can provide a copy of that even.
Does the buyer know that there is a pending violation of this nature on the property?
No, ma'am. The buyer only knows that it needs to be fixed according to the city's ordinance, because they went to the city to find out what can be built. I think they were trying to build something more than just fixing it. So
I'm gonna, magistrate, I'm gonna defer to the assistant city attorney and ask her opinion on if you were to adjudicate on the matter and the property were to transfer or title were to be transferred, what, or, I mean.
Well, if it's we're going to defer to the assistant city attorney. I mean, of course, get her legal opinion on that. I mean, in general, under the Florida title standards book put out by Attorney's Title or whatever, it is best practice to go to the local jurisdiction where you're buying a home and inquire as to whether there are violations there. That being said, the only sure way that I know that a third-party purchaser would know is if there is actually a violation of record. That would make it it's not even debatable, but it's suggested practice by the fund that you go check to see if there are water liens, code violations and so forth. But I don't, I'll defer to the assistant city attorney, Alberto.
I'm not sure I heard her question correctly because she was in and out. So
the director will repeat the question.
Yes, it was actually me. I was asking if we were to, or if the magistrate were to adjudicate on the matter today, because the city's concern is that, I mean, as the property owner mentioned, this is now the second buyer. The property has remained in the state in which it's in since the fire, which was dating back to April. I mean, given the circumstances, I mean, there's no guarantees that this transaction will close, and even after the transaction closes, that the property owner or the new buyer will, immediately remedy or rectify the issues. So my question to you, Madam Assistant City Attorney, would be if the magistrate were to adjudicate on the matter, would that prohibit or prevent her from being able to transfer title? Or I don't know, I guess are there any ramifications or any issues that we may want to consider before rendering the order?
Well, my understanding is that every time there's an adjudication on the property, whoever inherits, has the land, they inherit that violation and they have to deal with it. But I would continue this hearing and we can do further research to understand more what would be the ramifications for in a situation like this.
Can I interject?
I think the Ms. Quinn, you have your hand up, and we're not in school here or anything, but I'm sure you're going to be able to speak. I don't know if someone else. Yeah, I mean, I think what the assistant city attorney has said is correct. I mean, it's sort of like you bought it, you buy the violations on the property. as to the specific ramifications beyond that, that's, as I said, it's better practice to check with the city if there are violations, but I don't know that there is a law that actually requires that, frankly. So, I mean, I'm ready to adjudicate. I would have my own, but yes, Officer Beswick or whoever wants to speak.
Yeah, that's me. Okay, so basically, if there's adjudication on the property, the violation is in the property. If there's the process is this: before somebody purchases a home, they do a lien search. So the lien search will show the violation or any pending open violation. But in her case, my guess it would be an investors. Investors don't go through that process; they just buy it as is. So basically, they could take responsibility whatever come up later.
And that sounds correct to me. And when a lien is certified, it certainly is of record and would give notice to everyone. And again, it's encouraged that you check with the city to see if there are pending violations that are not yet certified. But again, I'm just not personally aware of a Florida statute that says you must do that. But yeah, basically you buy the violation when you buy the property. I could, depending on what the city wants, the matter can be continued. I just have a general tendency to try to deal with things if I'm able to do so when I'm sitting here, but I'll defer to the city on that.
Yeah, I mean, I'm personally okay if you feel comfortable ruling on the matter. It's the first time it's being heard, so we would only be entering an adjudication at this time. But Madam Assistant City Attorney, if you have an alternate perspective.
I don't. At this point, it's just a matter of whoever get that property later on. They're the ones who are going to have issues if they don't know that there's a lien on the property or a violation.
So I think the property owner too would have the responsibility and the onus of disclosing.
Right.
Yeah.
Yeah, I believe that Florida, again, I'm certainly not going to advise you, and I'm not advising you, and I'm not your attorney, et cetera, but I believe, Ms. Quinn, you have a duty under Florida law to disclose the situation to whoever.
I would never consider otherwise, Your Honor. So I guess my point or my question at this point was, I wasn't aware that I had to do that. So if that's what I have to do, because I wouldn't want to try to sell something that in any dishonest way. It's just not my way. So the fact that the property has had a casualty loss is what's known as a patent defect. It's very visible and it's very clear to the naked eye. But the fact that you have a code violation is, to my mind, what you need to disclose, because that would not be known unless someone is doing due diligence. That's just my view. Again, just informally, so. I know I had a code violation. I don't even know what the violation is since nobody lives there. So I didn't know it was a code violation. I thought I was being given time.
No, but there can be, Ms. Quinn, there can be, if someone owns property and they don't live here, if the property is in violation of the code because it's suffered a fire or because it's caved in or because, the roof is falling, it doesn't matter if someone is living there or not, there's still a violation. You understand?
Okay. I'm understanding now, but funny, I don't have a roof caving in. The 2 or 3 people I took to show it to them to find out the cost. There wasn't a roof caving in. The roof had nothing to do with it. They told me if I replace 2 thrusters and go through certain things, I just didn't have the $100,000 to do it. So I had to make a decision.
And again, I don't want to pry into your personal. But you don't have a homeowner's insurance that you made a claim on for this, or fire insurance or anything?
No, sir, I did not. That was the problem. I did not at the time. And if I did, I wouldn't be going through this. So what happened was it happened in April. Sorry. I didn't have insurance, and I was told I had 2 weeks to pay an architect $20,000 and bring a plan to the city. And I was like, how can I do that? I didn't have the $20,000 to pay an architect
Yes, I
to draw
understand.
up a plan, and that I'm just amazed. This is the process that, like first I incurred a loss of 100,000+, and now I'm told if I don't get it done in 2 weeks. I didn't get that. I'm learning it, and I'm a little frustrated. I didn't know that I can be penalized on top of losing it. That I just didn't know, especially when I took such good care of it. It's the property is set back. It looks better than half the properties around it, even though one side is perfect, but nobody's living there. I understand yard, nobody's going in there. I mean, I don't understand how I can be charged on top of, because I didn't have the 20 to pay with, so now I have to pay on top of that. I just don't understand the process.
Well, I'm certainly right. I'm merely a magistrate. I'm not a spokesman for the city. I don't decide what cases come here or not. So I'm not. It's not for me to. So I don't know. Again, I'm willing to move forward with this. It's not a day-to-day scenario, but I would take into account all the considerations. If you want me to go ahead and rule, I'm ready to do so in terms of placing a time frame.
Please, just give me some time, a week. I'll show up to, I'll do what I need to do.
Ms. Quinn, I'm thinking of much more than a week. But, so do you want me to go ahead with an order then?
Yeah, Magistrate,
right.
you can.
Okay. I find that under the evidence and photographs and testimony of the officer and the others, all in the record as shown and accepted into the record without objection, that there is a structural issue of substantial damage to 121 Avenue.
We can't hear you.
You can't hear me now?
Now, yes, but when you lower your head, we can't hear you.
You can't hear me when I lower my head. Okay. I'm going to speak into wherever it is that the devices, the audio devices here. I'm not sure. So I do find that it has been shown that there is a structural damage of a substantial nature to the structure at 12125 Northeast 7th Avenue in North Miami. I believe it's been
frozen.
Northeast 7th Avenue, and I believe that under the facts and the circumstances, the city has shown that to be the case, taking into account all the testimony, including that of the owner, who it appears by all accounts to be working very, very productively to sell the property, which is her prerogative. I'm going to give the owner 120 days. 120 days to come into compliance.
120 days. Okay.
120 days. Right? You heard me.
I so appreciate that. I won't need that, I promise you, but I appreciate it very much.
120 days. Well, you've had a casualty loss there that I'm not. No one has mentioned arson or anything, so I believe that it's an act of God, and that has to be taken into account. That is my view, and I'm the magistrate today. So, what would be the recommended fine to be imposed?
Anything.
What? No, Ms. Quinn, I'm not asking you.
It would be similar to everything else, Magistrate, for a first-time violation up to $1,000 in your discretion.
Okay, I just needed to, again, it's not a routine kind of case. I think taking into account all the facts and circumstances, and that it's a residential structure, which does not appear to be occupied. It is not a commercial structure. The daily fine after 120 days, if there isn't compliance, would be $250 a day. The $100 administrative fee is imposed today. Ms. Quinn, the $100 is imposed today because there is a violation.
Yes, sir.
And that has been shown
Yes,
by the record. Thereafter, it would be $250 until compliance is achieved. And that is the ruling, and I gave the reasons for it. And if you have any other questions, Ms. Quinn, I would encourage you, if your system is working, to ask them now, and if not, to contact the city.
Yes, sir.
And be sure that you're
Yes.
very understanding of how this will work and what you need to do in terms of moving forward with your sale, and yes, anything else.
Well,
So
thank you for your time.
No, thank you. I'm sorry about the experience you've had. I understand your explanation. I do not think it is your fault, and I think all that has to be taken into account. And if there's
Thank you for
nothing,
your kindness.
it's just yes. So, is there anything else? If not, that concludes this matter. No, I guess not hearing from anyone. Well, that's the order. That concludes this matter, and we can move on to the next matter.
Ellie Renier, are you able to use your audio?
Mr. Renier, are you there? We're just gonna we had a gentleman earlier, magistrate, who was having difficulties with his audio, so we're just looking to see if he's resolved.
Yes, the mature gentleman that there he is. Yes.
Hi, Mr. Renier, can you hear us?
Hello, can you hear me?
Yes, we can.
Hello, Renier. Please raise your right hand.
Can you hear me?
Yes, we can.
Yes, we can hear you. Can you hear? Yes, raise your right hand. Raise your right hand, sir. Put on your headphones and raise your right hand. Maybe
I don't
you-
get. Oh, boy. Let me do this thing.
Okay. Okay.
Hello?
Can you hear
Yes.
us? We can hear you.
No, I'm not hearing.
Your headphones plugged. I look. I don't want. Do you have them plugged into the device? If not, is the audio working on your device?
Sir?
Renier, can you hear us?
Oh boy, I'm here, but I cannot hear.
Can you put your volume up?
If you can hear me, wave for me, please. Okay, good. All right. Sir, I'm trying my best to resolve this. About a week ago, I spoke to somebody in housing, and they told me to get it back in touch with the attorney that had helped me resolve the probate on the house, which I did. Yesterday, I received 2 documents from him.
Yes,
And
yes,
a
Mr. Renier.
quitclaim.
Yes. Wait a minute. Because before you just go telling us what you want to say, which I understand we're going to listen to, we have to hear the case from the city. We're either going to be able to do that in a orderly way, and I have to know, seriously, all kidding aside, I have to know that he can hear it, because if he cannot hear this due to due process, I really have no choice but to table it. I don't like to table things. I don't like to continue things. But if this gentleman can't hear what is being said here, I really don't think we can go forward. All right? I'm being perfectly serious.
Can you hear us, Renier?
I still cannot hear. Hello?
Can you hear us?
Oh, okay.
So you can hear me, right?
Yes, a little better.
Okay, can you raise your right hand?
Oh, yes.
Do you solemnly swear or affirm the testimony you're about to give in these proceedings shall be the truth, the whole truth, and nothing but the truth? So help you God. Please say I do.
I do.
Yes, please keep the headphones on. Do not move or go anywhere else.
No, I will not move.
Yes.
All right,
And let us hear from the city first.
Okay.
As to the city is going to give a overview
what
of
the
each
violations
case.
are.
Yes.
Okay.
Yes. And what the city's recommendation is to me. Then, Mr. Rainier, and only then, you'll have the full opportunity to speak, but the city will present its case first.
I
Then you-
apologize.
Yes, no, no, there's no need. Please, no need for any further apologies. So let's hear from the city as to each case,
Aaron
including,
Sorry. Yes, sir. There are 3 cases for this property. Aaron Barber, City of North Miami Code Compliance. The first case, case number CEFAW 2021-00036, is reference to a damaged chain link fence at the property. This violation was, the initial inspection was December 29th of 2020. Adjudicated, and as of the final recheck date, which was August 5th, 2022, there is no compliance. Would you like me to proceed with the next 2 cases, or would you like to hear them one at a time?
I'd like to hear them expeditiously, one at a time. What was the fine in this first case?
The fine, the abatement date was August 5th, and the fine was set at $150 plus court costs.
Okay. Do the same narrative testimony for the other 2 cases, and then we're going to hear from Mr. Rainier as to all 3 cases.
Yes, sir. Next case. Case number CEODS 2021-00082. This case is reference outdoor storage. The violation, the initial inspection was December 29th, 2021. The case has been previously adjudicated with an abatement date of June 6th. The case had then, I believe it was postponed. I don't know if the clerk has more information on that. Fine was set at $150. And as of the final recheck date of August 5th, there was no compliance.
Okay.
And the
and in that case, did you I'm sorry if you said it, but I know that he has multiple. The second case,
yes, sir.
Was there anything other than outdoor storage, or that was it on there? It was the outdoor storage issue.
Yes, the second case is for the outdoor storage.
All right. Okay. And the third case? Again, the same facts.
Yes, sir. Third and final case, case number CEWWC 2021-00041, is in this case is for the condition of the roof. Roof is in a very, very poor condition. I would like to have the building official give testimony if possible. The initial inspection was December 29th, 2021, case previously adjudicated. And the fine was set at $250. The final recheck date of August 5th, 2022, there was no compliance.
Is there anything else on any of these cases?
The only thing I might add, I know that there was the magistrate further order to allow the city to access into the home to assess. Yes. And I don't know whether or not the building official has made entry. I have not seen the inside of the home.
And is that because you were unable to, or is that because you did not go to the home?
I have been to the home. Mr. Rainier has been, from what I understand, he has been sick. He has not been home for some time. And again, I don't know whether or not the building official has been able to see the conditions of the inside of the home. But my concerns are specifically with the third case with the roof, the conditions are pretty bad.
Yes, all the photographic evidence is accepted and in the record without objection.
Yes, sir.
I do recall these particular cases. I believe I heard them, and I do recall the condition of the roof as being extremely deteriorated, and that is evident in the photographic evidence you showed again today. Is there anything else at this time, Officer Barber?
No, sir, not at this time. Thank you.
All right. Does the building official have anything they want to add about the roof or about going to the property or otherwise?
Mr. Magistrate, I hadn't had a chance to go inside the property, and I've been there with Officer Barber, but I was unable to go inside the property. But from the street view, there's some issue with the roof going on there, and I would hope that I could see inside to see, if there's a danger.
You weren't able because he was not there to let you in.
Yes, right. There was no access, correct.
So the city attempted to go inside the property, but there was no one there to let you in.
Yes, correct.
Okay. Is there anything else you want to add?
No, I mean, the only thing I'm concerned with is just the roof and him living in that house. So I really don't know. From outside, it looks like there's some serious issues with that roof, and it's also I think he has a tile roof as well. So I'm just concerned if he has some areas that are kind of caving in with those tile roofs, kind of getting dislodged and falling through the roof. So I'm just concerned about his safety in the house there.
Thank you. Thank you very much. Mr. Rainier, are you living on this property now? Are you living there?
On and off.
On and off. So I need you to, I need to know on the record that you're going to be available for the city to go and have access to your property. We discussed that last time and you said you would. Okay. I need to hear that you're going to give the city free access to your property. Are you?
Sir, okay. Can I explain myself, sir?
Yes, you can explain yourself, but I also need you to answer the question. Please.
Oh, definitely so. Definitely so.
Okay.
A couple of times.
Do you have a cell phone?
Yes, I do.
And does the city have that cell phone?
Ms. Barber has it.
Yes, sir.
Okay. I need those arrangements to be made because this was the same discussion we had last time, and here it is, sometime later, and the city still has not gone into the property. So I just wanted to address that. So, Mr. Rainier, go ahead. What do you want to say?
Okay. Now, if you look at the picture that Ms. Barber showed you of the fence, you can see I have some pipe that I purchased at least 4 or 5 months ago to try to resolve that situation with the fence. But I've been very sick, in and out. I almost had a couple of my toes amputated. So I was in the hospital for, from the beginning of June until about 4 or 5 days ago. Okay? And what happened is this. Ms. Barber mentioned about the storage of the things in front of the place. If she can see that I try to move as much of it as possible, sir, the problem I'm having is I have no strength to move a lot of these things. People who were staying there, like they said, they abandoned ship. I'm left here to resolve the situation myself. About a week ago, I called somebody in the housing department, and I was explaining the situation to them. And they told me, why don't try to get in touch with the attorney that did the probate on the house and see what can happen. So I did. So yesterday, I received 2 documents from him called quit claim deed, to have my sister sign one and my niece sign the other, so that I can get the property in my name solely so I can approach the bank to borrow some money to try and do the roof. Because when I was asking about the city helping with the roof, he said, well, it's like a lottery. They pick 20 houses within the city and they try to do that. There's no guarantee that I will be one of them that's going to be selected. So I'm trying to go through the bank, try to go through the credit union to see if I can borrow some money on the equity of the house, you know, to try to solve this problem. I don't like living in the condition the house is, you know, but sir, I have no choice until I can get this resolved. You see, you know, if for me to get my niece to sign it, I have to travel to the Bahamas. I have a ticket I've already purchased when I was supposed to have gone there from like I said, the end of May. All right. I still cannot travel because my pressure has been so high and my diabetes been acting up. So I'm trying to get all these things resolved. Now, in regard with getting access to the house is in poor shape. Okay, it is in poor shape. Okay, but it's either I be there or I'm gonna go under a bridge or somewhere, and that's what I'm trying to avoid from happening. You see, I work with Dade County Public School as a substitute teacher, but it's like
are you on the premises now when you're speaking?
Yes, I am.
Okay, so that is the house, and you're on the side of the house.
Yeah, I'm on the porch.
You're on the porch of the house. Okay. Is there anything else that the city wants to say about this?
You know, sir.
Yes, or you, Mr.
Okay. All I can ask is that give me a little bit more time to try. Okay, now that I'm about to get the property in my name, definitely I will try to solve the roof problem because, sir, if you don't have the money to do it, how can you do that? If you go in the store and you only have $5 in your pocket, can you buy $10 worth of food? No. You see what I'm saying? So I'm trying.
Well, if you can, I'd like to know how. So, but yes, go ahead.
You see, so this is why I'm trying to go through my credit union to see if I can borrow on the equity of the house. You know, because like online, you see all kinds of these people offering. Oh, you need a new roof. You get a new roof. Oh, you pay $100 or $99 a month, something like that. I say it must be some kind of scheme. You see, because the last time I had a roofing company came and inspect the roof to give me an estimate. The guy told me $56,000 to get me a new roof. I said, thank you, sir. All right. So this is what I'm trying to see if I can go alternate route by going to the credit union and see if I can get the money to try to get this resolved.
Thank you. Thank you. Is there anything else that the city wants to say or anyone wants to say about this?
Yes, sir, if I could. The last time I was at the property, I was able to, I actually went up on the porch and was knocking at the door. We're trying to check and see if anyone was there. And in the photos that were taken for the roof case, the window near the area where Mr. Rainier is sitting now, it appears to have roofing material inside. So I don't know. Again, my concern is just the conditions of what's left of that roof, because if it's collapsing from the eaves and the soffit starting to collapse inside the home, I think it's something that we should, our building official, we should be able to check that out.
Well, if the city wants to bring an unsafe structures case, that's within the sound discretion of the city, within applicable county rules and regulations, since you use the county program. That's not for me to decide.
Yes, sir.
That's something that's within the province of the city. I will say this. There is a There's a prior, I'm going to ask a question of the director or the assistant city attorney. It's a procedural question I have actually. There is a prior adjudication of guilt here, and there is a abatement day of August 5th, I believe, for these cases, right? So, do I have any latitude to modify the fine amount that was previously imposed, or is that already set? You understand my question?
I believe you can make those changes if you see fit. And I don't know if you have anything you want to add, Madam Assistant City Attorney, but I think so.
Yeah, I agree. Yeah, that would be my answer to you.
I'm going to issue these orders, and Mr. Renier, please listen carefully. On the first case, due to your circumstances and your health and your situation in general there, but taking into account all the factors here and the evidence, which is all admitted into the record, as well as Officer Barber's testimony, and taking all into this account, I do find that there is shown a violation of the chain link fence that has been demonstrated by competent substantial evidence. Nevertheless, considering the relative lack of gravity of that violation, the fine I will impose is $50 a day. It will commence the day after the abatement date, which is August 5th. So it will commence on August 6th. It will be $50 per day plus a $100 administrative fee because a violation has been shown. As to the outdoor storage, Officer Barber, a question for you. When you were there, was the outdoor storage somewhat alleviated, or was it any better, or was it still full of objects outside?
The last, Mr. Renier has placed a truck on the side of the house so he can start loading things up. It's one of those junk company trucks. However, the items were still, the last time I was out there was before he came home from the hospital. The items were still in pretty bad shape. It was still quite a bit of outdoor storage.
Would those items be any kind of any kind of projectile or any kind of situation that could cause damage to other properties there?
It appeared to be some lawn equipment, old bits and pieces, tools and things like that. I don't know whether or not anything like that would be considered a potential projectile.
You didn't see like a washing machine out there, or barrels, or
No,
bricks,
sir.
or anything like that. Okay. I am going to find that the city has shown, based on the evidence,
I hear you, Magistrate.
I'm going to find that there is a violation shown of outdoor storage as charged in the notice of violation, in the hearing notice, and the fine for that will be $50 per day, commencing the day after the abatement period. So that would be commencing on August 6th, plus a $100 fee. As to the last case, with the condition of the roof, I consider that a serious case. I consider that to be a matter of great gravity. It seems by all accounts on the evidence that the roof is in a very, very poor state. That could present a public safety and health hazard to Mr. Rainier himself, living on those premises, that could cause injury or damage or worse to him. And if the city left that unchecked, it could conceivably, just in my opinion, create some kind of theory of liability for the government to be aware of that situation. So I think that the violation of the condition of the roof has been shown by the evidence of record. The fine there will remain at $250 a day. That will commence on August 6th, the day after the last inspection, and continue each day until there is a correction or cure, plus a $100 admin fee. I would encourage the city to work with Mr. Rainier to see if there's any kind of program that he's eligible in to remedy this. If not, Mr. Rainier, you're going to have to send your agent or nephew or someone out there if you're saying that you need total ownership of the property to get a loan. I understand your situation, but this is very serious with the roof. You have to act very quickly and actively, and you'll need to go to the school board credit union or however else you're going to do it to get a loan to re-roof the house, because based on the conditions and the testimony, it seems like the roof is in a deplorable state and presents a safety risk. So that's the orders. If there's no other questions, and Mr. Rainier, be sure that the officer has your cell phone and that you're fully available.
Miss Barbara has my phone number, sir.
Okay. Well, then I hope that before this matter is, God forbid it's ever heard again, but before it's ever heard again, that the city has been successful in at least having one, fully accessed visit to the premises inside and out, and can address that with the magistrate at the time.
Thank you.
So thank you. And that I hope you've understood, Mr. Rainier. If not, please call Miss Barber to further explain it. Thank you for appearing. I hope you feel better. And that's the orders in the three cases.
Thank you.
Thank you.
Jocelyn Monstein, what case are you here on behalf?
Jocelyn Monstein, what property are you here on behalf of? At this time, the interpreters, you guys may be dismissed. I'm not hearing anything or seeing anything from this individual, and I think they just signed in. Perhaps they're here just to observe. I'm not sure.
Yes, hello?
Yes, Ms. Monstein.
What case are you here for?
Driveway.
Monstein, qui case ou la? Pour qui case ou vini?
Driveway. Yam kaze, yo.
Okay. If I say driveway, qui know qui so on property yan?
Jocelyn Monstein.
Numéro Kayla.
1570 Nord-Ouest 126 Street. Miami, Florida 22167.
1570?
Yes.
Ou te jwen nou let pou vini jodi ya?
Oui, let la. Dem te fin kaze drop yon te rele inspecte yon te vini. Apre sa mwen.
Comment inspecte a rele?
Like Miss Barbara.
Aaron, is this case on your agenda for today?
No, it's not on the agenda for today.
Was she tabled?
No.
18.
Okay. Madame Monstein, ou pat bezwen vini jodi ya, nap fe code officer a fe an rele ou pou l ka pala pou l ka explike ou sa ka pase avek Kayla konya, okay?
Okay.
All right. You have her number, Aaron?
No, I don't. I'll go by.
You know the address?
Do you know the phone number?
I do. 786-587-8524.
Okay, I've got it. Thank you.
All right. At this time, Magistrate, I think we've finalized all of the attendees. The agenda is not concluded. We still have items here that are unrepresented after being noticed of today's hearing.
Well, we can, efficiently travel through those items that there's no representation. For the record, I want to announce that all other items will be heard in an abbreviated manner because the respondents, having been noticed, have failed to appear, and there is no respondent party or violator present, and therefore the cases will be done in a somewhat abbreviated manner.
Okay, thank you. In short, for the code officers, please make it quick.
Right, that's what I meant to say.
All right, clerk.
Item number 3, 13080 Ortega LLC, case number CEVPR 2022-00392. This case was previously found guilty, must abate by June 3rd, 2022, and fine was set at $500 plus $100 cost assessment. The officer is Jose Perez.
Officer Perez with the City of North Miami to hearing the case in regards to the property at 13080 Ortega Lane. This violation is in regards to building permits that were not obtained. The property was posted on March 29, 2022, when was sent via certified mail on the 30th. My apologies. Those are the dates for the prior hearing. Gosh, I have here. The property was posted and was sent via certified mail on July 29, 2022. The property has still not obtained permits for said construction as of my final inspection dates. When I checked the permits, it says that the electrical plans were denied. At this point in time, the city is asking for the fines to move forward.
Based on the unrebutted testimony by the code enforcement officer and all evidence of record, which is admitted into the record, this violation has been proven as charged, and in the notice and in the original violation notifications. Did you tell me, and I apologize, officer, if I didn't write it down, did you tell me what the abatement date was for this?
The abatement date for this was
June 3rd.
June 3rd.
Okay, thank you. The violation has been found to exist. The $500 per day fine will commence to accrue on June 4th, the day after the abatement date. It's hereby imposed along with the $100 admin fee that is standard anytime a violation has been found. That's the order. Thank you. That's it.
Item number 4, this is a new case. It's item number 4 and 5, 13100 Sunrise Plaza LLC, case number CEFOB 2022-00124, and as well as item number 5, 13100 Sunrise Plaza LLC, case number CEZCU 2022-00268, and the officer is Shannon Sanders.
And these are new cases.
New case.
Okay.
Shannon Sanders, City of North Miami Code Compliance Officer. As I already stated, these are new cases for 13136 Northwest 7th Avenue. One for not obtaining the certificate of use. The other one kind of coincides with it not having the business tax receipt. They go hand in hand. This is for business J&S Variety that was originally cited February 1st of 2022, whereas I spoke to a gentleman that identified himself as the business owner. As of he stated at that time that he would contact the city and do whatever he needed to do to submit his applications. As of my last inspection, no application has been submitted to the city regarding this matter. As of my last reinspection on the 5th of this month, the business still remains open and fully operational. I am showing proper service was given. The notice to appear was mailed out and posted, I'm showing same day, July 22nd, 2022.
And so they haven't done anything relative to the BTR or the CU.
It doesn't show that they've submitted an application for either one.
What is I always ask well no, I don't always ask. I'm going to ask in this instance. The respondent has not taken the time or attention to appear, which is certainly not impressive to the magistrate. What is the shortest time frame that the city has used in the past for requiring a BTR and a CU?
Magistrate, I think you have, if I'm not mistaken, you have there's several dates that you can pick from before you in terms of abatement. Peggy, do you know what the immediate next abatement date would be?
The next abatement date is September 2nd.
September 2nd.
I find that JNS Variety has been shown by competent substantial evidence not to have a BTR as required, charged in the notice and in the hearing notices. They will have till September 2nd of this year to obtain the BTR. If not, there will be a daily fine thereafter of this is a commercial establishment, right?
Yes, it is.
Correct. Of $250 a day, and the $100 admin fee is also imposed since a violation has been found. And I find similarly that JNS Variety, it has been shown by competent substantial evidence, all in the record, as shown without objection, and there being no respondent appear, does not have the CU as required by applicable regulations. They will have till September 2nd, 2021 to obtain the CU. If not, there will be a per diem fine thereafter of $250 per day until compliance is achieved. The $100 admin fee is also imposed, as is customary, anytime a violation has been found. And that will be the order in both of these matters, in each of these matters.
All right. For the next items, we have from item number 6 all the way to 14. I'm gonna read each one of them into record. Item number 6 is 580 North Miami LLC, case number CEFAW 2021-0019. This case was previously found guilty with an abatement date of July 8, 2022. Fine set at $250 plus $100 cost assessment. Item number 7, case number is CEFOB 2021-0023. Previously found guilty with an abatement date of August 5th, 2022. Fine set at $250 plus $100 cost assessment. For item number 8, for the same property owner, 580 North Miami LLC, case number CEMHS 2021-0047. Previously found guilty with an abatement date of August 5th. Fine set at $250 plus $100 cost assessment. Item number 9, case number CEMHS 2021-0048. Previously found guilty with an abatement date of August 5th, 2022. Fine set at $250 plus $100 cost assessment. Item number 10, CEMHS 2021-0049. Previously found guilty with an abatement date of July 8th, 2022. Fine set at $250 plus $100 cost assessment. Item number 11, case number CEMHS 2021-0051. Previously found guilty with an abatement date of August 5th. Fine set at $250 plus $100 cost assessment. Item number 12, CENUS 2021-00446, previously found guilty with an abatement date of July 8, 2022. Fine set at $250 plus $100 cost assessment. Item number 13, case number CEWWC 2021-0026, previously found guilty with an abatement date of July 8, 2022. Fine set at $250 plus $100 cost assessment. Lastly, well, not lastly, item number 14, case number CEWWC 2021-0027, previously found guilty with an abatement date of July 8, 2022. Fine set at $250 plus $100 cost assessment. Lastly, case number CEZCU 2021-00137, previously found guilty with an abatement date of August 5th, 2022. Fine set at $250 plus $100 cost assessment, and all those cases are for 580 North Miami LLC. Any officer, Shanna Sanders.
Shanna Sanders, City of North Miami Co-Compliance Officer, starting with the first case for the fence being CEFAW 2021-00019. This is a case that's already been adjudicated. As of my last reinspection, compliance has not been met. Just to give a little briefing, they recited for the fence, the cement wall needing repairs. Long story short, the cement wall was repaired but without obtaining the permit. In the description when cited, it was stated to repair the fence and to repaint it with the proper permits. Again, violation was taken care of but without the proper permits.
And the permits were mentioned, Officer Sanders, in the violation.
It definitely states yes, apply for and obtain a permit to repair and paint the cracked cement wall surrounding the property.
Okay, go ahead.
Again, as of my last reinspection on the 5th of August, the violation still remained and no permits have been secured. I am showing that proper service was given. I posted the property on the 7th, July 22nd, 2022. And I am showing that it was also mailed out on the 28th, certified mailing.
That case number 7 is the defense. I find that by competent substantial evidence, all is showed in the record and all accepted and unrebutted, there is a violation of the permitting requirement for the fence shown. The fine will be imposed starting daily at $250 the day after the abatement period, which would be August 6th in this case, plus a $100 fine. So we can proceed to the next case.
Shanna Sanders, same property address, 580 Northeast 127th Street, for case for not having their business tax receipt. Case number CEFOB 2021-00023. They were cited back in September 7, 2021, where it was brought to their attention while doing the annual housing inspection that they needed to obtain their business tax receipt. As of the last reinspection on August 5th of this year, the business tax receipt has still not been obtained, nor have it been applied for. I am showing proper service was given. The notice of violation was posted at the property on the 22nd of July, as well as mailed out certified mailing on the 28th.
As shown by the record evidence, which is unrebutted and which is all accepted into the record without objection, I think that the violation,
Can I hear you, Magistrate?
a violation of 580 North Miami LLC not having the BTR has been adequately shown and demonstrated. The daily fine until the BTR is secured is $250 a day, commencing on the day after the abatement date, plus a $100 fee is imposed because a violation has been shown. So that's the order on that case. You can proceed, Officer Sanders.
Next case, same property address, 580 Northeast 127th Street, case number CEMHS 2021-00051 for states they repaired the exterior walls, had cracks, exposed rebars, needed a little fine tuning, needed a little, work done. Long story short, they did do the work, they did the necessary repairs, just without the permit. It does state in the application and in the description of the violation that permit must be applied for and obtained from the building department to do such work. As of my last reinspection on the 5th of August, violation still remains and permits have not been obtained. I am showing proper service was given. I posted the property with the notice to appear on the 22nd of July. Well, a certified mailing was sent out on the 28th.
And clearly here, Officer Sanders, the permit is required for this corrective work.
Yes.
Indisputably, the permit is required.
Yes, this is a commercial building, so almost all of these, everything needs permits for such work.
Okay. That 550 North Miami LLC has done this exterior work, but done without a permit as required by applicable regulations, as shown by the evidence and testimony on record, all which is accepted and unrebutted. Consequently, the fine is $250 per day, starting after the date of abatement, which is the day after August 5th, I believe, plus the $100 fee is imposed because the violation has been shown and demonstrated. Thank you. You may proceed to the next case.
I see some of these are out of order. I'm going to go ahead to case CEMHS 2021-00047. This is for the light fixtures being inoperable and needing repairs. Again, the work was done. They did some necessary repairs on the light fixtures. Some still need to be replaced. As I looked in that back stairway, I would consider that being the south end of the property. Some still needs to be repaired. But again, they did do some of them without the proper permits being secured. They have submitted an application to the city, but it has not been approved or obtained. I am showing that proper service was given. I posted the property on July 22nd. Certified mailing was mailed out on the 28th. As of my last reinspection on August 5th, the permits has not been secured, so has not been secured or obtained, so the violation still remains.
But they did submit permit that was not rejected or kicked back by the city, as far as you know.
It was rejected and kicked back. What happened was, just to give you
it was.
Yes,
Okay.
it was kicked back. They had some plumbing situation take place there last year, September, whereas they obtained a permit to do the repairs. It was emergency work that was done. They were immediately cited that following Monday or Tuesday and was instructed to visit the building department. Again, they obtained the permits for that. Now, when we went out a couple of days later, if not a week or two later, to do the annual housing inspection, we noticed more work being done. They submitted a revision to the existing plumbing permit that was issued in September, but nothing has been secured and obtained. Almost everything that they have applied for has been denied for one reason or the other. I appreciate that very descriptive narrative, but how does the plumbing permit relate to the electrical permit? Because this is our electrical permit and lighting. I just don't understand how they're connected. And I've had a conversation with the building department in reference to this, and that was my frustration when I first received this violation. And I'm not in the building department. I started off there, many months ago, but it should have been a new permit altogether, because the property owner's stance keeps, they continue to feel they have a permit, but I told him that's for something totally separate.
They're using the same permit number as the plumbing permit.
Yes, and I tried.
But that's not. Again, it's not for me to comment on that, but that is. I will comment on that. That's confusing and can lead to complications. There should
Yeah,
be
and it,
there should be a separate permit number.
and I instructed them to do that, but and, and I see the building official, just blinked in, so maybe he can give quickly some insight to it. It was very confusing when I first got this violation when I saw that.
There should be different permit numbers for different disciplines. I mean, that's what I believe has always been the norm. Mr. Building Official, do you want to say anything quickly about this?
Yeah, Mr. Magistrate, I think when this started off, this is the building behind the thrift store.
Yes, right behind Red, White, and Blue.
I think this was my second day there. I think, my first day here at the back at North Miami. I was blessed to visit that building, but it started off as they had an issue with the plumbing stack, and but eventually they had to redo the bathrooms. I think in 3 levels.
Yes.
So it's both building permit, but it has sub permits of plumbing and I think they went outside the bathroom and we're doing kitchen remodeling, some other remodeling in the unit too. So
well, the plumbing is, I can see that as relating to restrooms or whatever, or kitchens, but I don't understand how that connects to electrical. It's just a point of interest. I don't, electrical is, lighting.
Because they had to gut the entire gut the entire bathroom or redo the entire bathroom. So in the bathroom, you have the lighting and the receptacles there. But I clearly remember, I think they were doing work outside that area as well.
Why isn't there a different permit number for the electrical?
Well, the way our permit is set up, there's a master permit which takes care of the overall work, but there's sub permits which is the same number, but it's basically on file. There's the general contractor, electrical contractor, plumbing contractor, and if there's AC work, there's a mechanical contractor there as well. But it's one master permit number, but within that master, there's sub permits in there. So I think.
So it's a city norm that even if there's 8 disciplines involved, it's going to be the same permit number for all those disciplines.
Some permits require separate. Some work requires separate applications as well. Like roofing is its own application, driveways.
But electrical and plumbing would be on the same permit number.
It would be under that umbrella of the master. Because I think with this.
All right. I mean, I don't.
Yeah. With this particular case, it started at I think the scope was supposed to be a certain thing. Then I guess it evolved with the people kind of going outside the scope of the permit to do other work.
Have you viewed the premises, and is the electrical work that was done there without a permit substantial in your opinion, or is it minor?
Are you asking me or the building official? I'm sorry.
No, I'm sorry, Officer Sanders. I'm asking the building official.
Oh, okay.
I'm asking him.
I mean, when I believe I went there on 2 occasions.
Yes, and
so I noted I saw on the second occasion, I think they were doing some work in the kitchen as well. So I mean that alone would need electrical permit, because the receptacles for any kitchen remodeling, you need certain receptacles with certain spacing, and also the receptacles would need to be a GFI if it's close by water. So it does have a electrical, regarding receptacles and
was the work, in your opinion, minor, if you have one, or was it more than minor?
No, more than minor. It was more than minor.
More than minor. More than minor.
Yeah.
Okay, I've heard what I need to hear. Based on the testimony and the evidence that is unrebutted, I find that there was electrical work done without a permit, which per the only testimony I heard from the building official, is more than minor work, and a permit is needed. So I do find that they are in violation of that code section as charged. The fine will be $250 a day, I think, as earlier prescribed, starting on the day after abatement, which is August 6th, and the $100 fee is imposed since a violation was found. No, I'm asking these questions. I want to go quickly, but I'm asking these questions because I believe in, adhering to the code, but I don't necessarily want to throw the book at everyone over every violation, if you follow what I'm saying. So that's my belief anyway. So go ahead, Officer Sanders.
If you can, Mark, please stay on because I have several for this property, if you don't
Yes,
mind.
I understand
Fine.
that.
580 Northeast 127th Street for violation CE MHS 2021-00048. Again, same thing. They did the work for the repairs to the stairs in railings. I guess upon the initial inspection, they were loose. I'm showing here comments stating that they had some cracks were observed. Again, the very shaky railings, they needed to repair and replace the threads and risers in the stairway. The work was done complete just without the proper permits. As stated in the previous one, and you'll probably hear with the next testimony as well, they submitted revisions to an existing permit that was issued that of course has been denied as of my last reinspection. Since the permit was denied and not actually obtained as instructed, and violation still remains, I am showing proper service was given. I posted the property with the notice to appear on the 22nd of July. Notice was officially sent out certified mailing per the office staff on July 28th. And violation still remains.
Based on the unrebutted testimony and the evidence all of record, which is admitted without objection, I find that there is a violation of the stairs and the railings and the prescribed date of abatement, which I believe in this case, if I per day until there is correction achieved, plus $100 fine because the violation has been proved. Go ahead, Officer Sanders.
Next case, CEMHS 2021-00049, same property address, 580 Northeast 127th Street. This one is for not having the proper screens in all the windows and sliding doors. Upon my reinspection, I did note that the screens had not still been installed. At the last hearing, the property manager, he identified himself as the owner, but I think he's the manager, stated that was a simple job, he would take care of it. Along my last reinspection on August 5th, the screens had not been placed in the windows as of yet. I am showing proper service was given. Notice was posted July 22nd, certified mailed out on the 28th of July. Again, last reinspection violation still remains.
Okay. Taking into account all the testimony and the evidence of record, which is unrebutted, I do find that there was a violation here due to the screens and windows not being done and completed and the lack of a permit thereof. Due to the multiplicity of violations against this particular premises and taking that into account, I find this to be a more minor violation. The fine will be $100 a day, and it will commence on the day after correction, which I believe here I wrote down, unless I'm wrong, was June 8th. That's what I wrote for this one. I could be
July.
I'm sorry. Effective after July 8th until there is correction, and each day thereafter, plus the $100 admin fee because a violation has been proven. So that will be the order on this particular violation. Go ahead to the next case, please, Officer Sanders.
The next case is CENUS 2021-00446. They were cited due to the situation that Mark already stated with the plumbing and the mold and things had started to grow in the unit. The city asked them at that time, in the code, requires them to submit during annual housing inspections a mold remediation plan. They need to show, that the unit was taken care of, that it was remediated, and what plan of action that they're going to take moving forward to make sure that the building or units does not occur incur mold in the future. Long story short, they did do some repairs. They changed the walls, did some work, things of that nature, but they never got a mold company out there in or provided any type of mold plans to the city. As of my last reinspection on the 5th, that plan had not been submitted to the city. Again, per my conversation with them via telephone call in at the property, we'll get that to you, we'll get that to you. But, you know, again, violation still remains upon my last reinspection. Proper service was given, notice was posted on July 22nd, mailed out certified on the 28th of July. Again, no compliance.
And the mold remediation plan, is that something that's uniformly required by the city of all similar structures where there's a mold issue?
That's correct. Yes.
So that's an across the board thing that the city requires compliance by the affected buildings, right?
Yes, all commercial buildings that has reports of mold and or complaints of mold.
Okay, that can be a public health matter. I do find that based on the unrebutted evidence and testimony, there is a violation of failure to comply with the mold regulations as prescribed by the city code that has been demonstrated and proven. The fine will be $250 a day. It will commence on the day after compliance, or as you call it, the abatement date, which I wrote down here as being July 8th, and continue each day thereafter, plus $100 admin fine because of violation. Fee, not fine, strike that, fee, because the violation has been proven. And I think finally, for this premises, you have one other case, Officer Sanders.
Actually, I have three more.
There's three more. Actually,
Yes.
I may not have three
Yes,
more.
Next,
Okay.
next case, CEWWC 2021-00027. This is for the actual doors, sliding doors in windows that were changed. They were changed, of course, without the proper permit. As of my last reinspection date, permits had not been obtained. I looked at the plans. I quickly, as Mark was talking, I don't even see anything submitted to the city with any changes or additions for windows to be added to that. So, you know, from what I'm seeing from this BBC 00-2021-00109 permit that they say they made revisions and added it to, I don't see it on there. So again, my stance is on my last reinspection minutes ago, no violation still remains for not having a permit for windows indoors. I am showing proper service was given. I posted the property on the 22nd of July. Certified mailing was mailed out on the 28th. Mark, it seems like you're looking at your screen. Do you see something different than what I'm seeing? No permit?
No, I was trying to look at the for a window permit. I don't see anything.
Okay, so yes, magistrate, no permit has been submitted, revised, obtained for the windows and doors that were changed at the property.
Thank you, Officer Sanders. Mr. Building Official, do you have any professional opinion as to whether this permitting windows and doors is a substantial matter, or would you consider it a minor or a moderate matter?
No, I mean,
what was that? I'm sorry, what was that?
Officer Sanders, how many windows and doors there were changed?
Let me look real quick to see how many units are in this building, because I would say every unit in that building had been changed.
So yeah, that's substantial. Because when they change the either doors or windows or sliding glass doors, they would need it would need to either be impact or they would need to provide impact rated shutter system or accordion system to take for to meet impact. So yeah, it would need to be be substantial.
So magistrate, I'm showing that this is a 30-unit apartment building. So let's say 2 windows in each unit, including sliding doors on the I guess on the 8 units closest to the south side. So we're looking at probably about 60 windows and maybe 8 sliding doors.
Okay, I think that I've heard what I needed to hear. This is a substantial violation. It's not a minor violation of the installation of doors and windows without a permit, as shown by the evidence, record admitted and unrebutted. Um, the fine, I think, as earlier prescribed, will be 250 per day. And unless I get it wrong, Officer Sanders, when was the abatement date for this?
All of these were the same, showing
Oh, they're all
all
give the date.
July 8th. Yes.
All July 8th. Okay, so it will be commencing the day after the abatement date, plus a $100 fee, admin fee, as a violation has been shown. What is your next case on these premises, officer?
CEWWC 2021-00026. This is for the leaks in the cracks, the damage that was caused due to the plumbing situation that was done, that occurred September of 2021. They did make the proper changes, as the building official stated. They already changed the wood, the doors. Looking at it, they did let me in upon my last reinspection, and there was noted the ceiling had even been changed, but again without permits. And definitely in the description it specifically states apply for and obtain the permits to repair the damage, leaks in damage to the ceiling in units 27, 37, and 47, the 3 units that was already stated in previous testimony. Repairs were done, but as my last reinspection on the 5th of August, compliance had not been met. Permits have not been obtained for those necessary repairs. I am showing proper service was given. Notice to appear was posted at the property on the 22nd of July. Certified mailing was mailed out on the 28th. I have not had further contact with anyone from this building since then.
Mr. Building Official Gene, the same question as I had in the last case. Does this sound like a substantial kind of violation for you of the permits?
Well, with that, it's kind of isolating those three, the 3 units. I guess the 3 bathroom units that's on top of each other there, in that section of the building. So it's kind of isolated in one area, but it's 3 units there. So
I'm asking your opinion as a building official. And the reason I'm asking, not that I need to explain it, but I'm glad to, is that anytime, in any case, so this is not personalized to anyone, that I see multiple violations with one owner or one person, I am always going to be more inquisitive, because someone hasn't been cited for 1 or 2 things. They've been cited for 8 things, and there's 8 different cases. So I have a different standard of my review. So please respond.
Okay. I wouldn't say that I wouldn't say that is substantial, but I can say this. When I first visited that property, with being 1 bathroom, basically it was unlivable because they don't have a restroom for that particular unit. So
it was unlivable.
It was unlivable because there was no. It was 1 bathroom.
And that was one of the units that's involved here.
Yeah, I believe it's one of the 3 units, because it is
one of the 3 units, and that one was unlivable.
Yeah,
and was it rented out and occupied?
Well, at the time, the tenants wouldn't. I posted a unit to be how do you call it? For the tenants to be evacuated from that, because there's no working facility for.
So they're still evacuated from there?
Upon my reinspection, I know that I'm chiming in because I know, the building official said he hadn't been back to the property. When I inspected the property, there was another tenant there. The other ones did say that they moved out. They were actually 2 doors down from, I think it was 37, but it was occupied by another, maybe middle-aged to older woman there.
So the unit that the building official described as being unoccupiable or not habitable because of a bathroom deficiency was occupied Is that what you're telling me, Officer
Yes,
Shannon?
I am. But keep in mind, this happened in September of last year. So just as we're seeing with all of these violations, I'm assuming, they've done the work and they have made repairs. They just haven't done them with permits. I don't know if it's up to par because again, they did it without permits. So no one has been in there to inspect anything, but per my visual eye, I know it was occupied in it. I didn't see any mold or mildew. I'm honest enough to say there was somewhat of a language barrier. I called and someone translated through the phone. She called her daughter and she was uncomfortable about letting me in. So again, I was only able to see a little bit from the door, but it looked livable. But that doesn't mean it is livable. That's why we require a permit so that we can get city officials out there to see what's really going on.
And to add, Mr. Magistrate,
yes,
that particular one, that particular permit is it's BBC 00-2021-00109. I believe that's the one, and the description reads: install 54 foot of 4-inch sanitary line from unit 47 to 37 to 27 to laundry plumbing contractors will stop work. The work after emergency repairs are done. Submit revision for framing and drywall repair. So that's the permit in question. But the thing is, it's not finalized. It was issued, but it's not closed. And it was.
And I understand the permit is still open.
Yeah, it's still open.
The description of the work that you just read out to us verbatim, does that seem like substantial work to you? Yes, no.
For that unit, yes, because it's a main plumbing sanitary.
Okay.
Yes.
Thank you both.
Okay.
I've heard enough that what I want to hear. I feel that here there is sufficient evidence to show that there is leaks and cracks and plumbing violations as shown in the original notices of violation and in the hearing notices that have been demonstrated. Therefore, the fine of $250 per day is imposed. The fine will commence the day after the abatement date, which I believe would be July 9th, 2022, plus a $100 fee is imposed because, of course, the violation has been demonstrated. Thank you.
And my last and final one is CEZCU 2021-00137. This is they are in violation of not obtaining their certificate of use, which we already previously heard the business tax receipt one. They kind of go hand in hand. With all these violations going on, they cannot submit the application for the certificate of use until they take care of all these open violations. The Community Planning and Development Department did state someone reached out to them about submitting their application, but again, nothing is going to move until they take care of all of these other things. Upon my last reinspection, application has not been submitted. No further revisions have been made for any of these violations, so the violations still remain. Proper service was given. Notice was posted on the 22nd of July, certified mailed out on the 28th. Haven't had any further contact with anybody from this property. I move forward and ask for the fines to, be pushed forward.
When was the date that they have to comply on this one for? Was it the same date as the others?
This one, yeah.
Yes?
August 5th. August 5th. This one is August 5th. Yeah.
This one is August 5th, so it's a different date than the others.
Yes, because if I'm remembering correctly, I think with the CU and maybe even the business tax receipt, they gave them a little while. They gave them a further time because again, they couldn't do anything until all that other stuff was taken care of. So we gave them an additional month, because they didn't show up.
And I understand. And refresh my recollection because at this point we've heard a fair number of cases. Is there a standard or average, for lack of a better word, fine amount for the CU? Is it $250 or is it or does it vary, or that's what I'm asking?
For the CU, now I'm not sure if it's $250. At one time it used to be double the cost of whatever the CU would be, but things have changed. I'm not, very, familiar with the exact fine amount. If the director or the assistant city attorney is there, maybe they can, say for sure, but I'm not sure, and I don't want to be on record giving out any
Rest for
misinformation.
magistrate, it's up to $1,000 at your discretion.
I think here, taking into account two factors, I think the violation has been shown of all the other violations, and the fact that the CU has not yet been obtained is a thing that, as they say, speaks for itself. So, taking into account that there are numerous violations as a negative factor, but also taking into account that there's numerous violations as, for lack of a better word, as a factor that the owner or respondents have to work with in presumably trying to resolve this issue if they can. I'm going to go for the middle, and I'm going to find that the fine is $500. It will be effective the date after abatement date of August 5th. Be effective the day after, August 6th. That's a $500 per diem fine until there is correction or cure achieved, plus $100 admin fee, because again, the violation has been shown by the unrebutted evidence and documents of record. Thank you. So I hope that there's not a ninth violation involving this property.
Oh, that
And
was
if not,
my
we can
last.
present.
That
Okay,
was my
thank you.
last one. That was the last one.
All right, thank you.
Thank you.
Item number 18, Bank Enterprise LLC, case number CEBPR 2022-00289. This is a new case, and the officer is Aaron Barber.
Good afternoon, Aaron Barber, City of North Miami Code Compliance. As stated, this is a new case. This case, this property was cited for building without a permit. The initial inspection was January 27th of 2022. I happened upon the property and I found a small crew there doing what looked like quite a bit of work. They were cited for electrical, plumbing, interior work without permits. Notice was mailed, certified, and posted at the property, and as of the final reinspection date of August 5th, 2022, there is no compliance. No applications have been made.
The work looks extensive. Does it seem that way to you, based on what your view of the premises?
Yes, sir. Yes, sir. When I was out at the property, there were a handful of guys out there working all at the same time. So like I said, the property owner has been notified by the certified mail, as well as a registered agent, all certified mail.
I think that based on the photographic evidence, testimony of the code enforcement officer, and all the other evidence of record, which is all admitted without objection and unrebutted, it has been shown that the violation is charged of doing work without a permit has been shown on these premises. They will have 30 days to secure the required permits. If not, is this a single family dwelling, or is this multifamily or commercial? Officer Barber, can you tell me?
This is listed as single family.
If not, the fine should be $250 per day, plus the $100 admin fee is imposed as the violations were demonstrated. Thank you.
Thank you.
Item number 21, Bishokoff LLC, case number FYBRR 2020-00014. This case was previously found guilty with an abatement date of December 14, 2021. Fine was set at $250, and the officer is Gary Beswick.
Gary, are you there?
He's coming on now.
Thank you.
I'm here.
Your case Bishop
Which one?
LLC for 12250 Northwest 7th Avenue.
Good afternoon, Special Magistrate. As just as the one before, this case, they submit a report, but the report shows some deficiency, and they haven't bring back a clear report as yet. So we're seeking to just move forward.
Okay. Is there anything else you want to add at this time?
No.
Okay. Based on the unrebutted evidence of record, all of which is admitted in the testimony of the officer, I do find that a Bischoff LLC is, Bishokoff LLC is, Shaka LLC is in violation of the 40-year recertification requirement under the building code. That is a serious matter. The fine, which I believe was previously already set or assessed at $250 per day, is hereby imposed effective after the day of cure or abatement, which was 12/14/21 per my notes. So that would be effective 12/15/21 until compliance is achieved, plus $100 admin fee as the violation is shown.
Thank you.
Item number 22, C&M Sweet Bakery Inc. Case number FYBRR 2020-0079, previously found guilty.
Comply.
They have complied.
Yes.
Okay.
So they have complied. Item number 22 is hereby removed from the agenda. No further actions needed on that.
Thank you.
Right, let's see, give me 1 second. Yeah, item number 32, Jesus Mincha Diero, case number CERCV 2021-00136. He was previously found guilty within the abatement date of August 5th. Fine was set at $250 plus $100 cost assessment, and the officer is Aaron Barber.
Aaron Barber, City of North Miami Code Compliance. This case has been previously adjudicated. Variance for boats that are stored on the property. Notice was mailed, certified, and posted. And as of the final recheck date of August 5th, 2022, there has been no compliance.
I remember this case, I believe. Is there anything else, Officer Barber?
No, sir. That's it. Thank you.
Based on the unrebutted evidence of record and the testimony, I think it is shown by competent substantial evidence that boats are stored on the property without the required variance permit. The fine is imposed of $250 per day, effective the date after the abatement date. So that would begin to accrue on August 6, 2022, right? August 6, 2022. And each day thereafter until there is compliance, plus $100 admin fee is imposed.
Item number 33, Lim Sang O and wife Yama Y, case number CERCB 2021-00131. This case was previously found guilty within abatement date of August 5th, 2022. Fine set at $200 plus $100 cost assessment. And the officer is Aaron Barber.
Aaron Barber, City of North Miami Code Compliance. This case was previously adjudicated. Boats stored on the property without variance. Property has been posted and notice mailed, certified. As of the final recheck date of August 5th, 2022, there has been no compliance. Concludes my testimony.
Okay, I see based on the unrebutted evidence, including the photographs of record, all of which are admitted without objection, that there are boats, there's marine vehicles stored on the property without the required variance permit. I'm not sure why this one is $200 instead of the $250, but I'm not going to disturb that. The fine is imposed of $200 per day, effective the date after compliance, which is August 6th, and each and every day thereafter until there is compliance, plus $100 admin fee as the violation has been proved. Thank you.
Thank you.
The next two items is Malky Condominium Inc. Case number for item number 35 and 36 is MGIO 2022-00276. And item number 36, case number is MGIO 2022-00277. And the officer is Tamara Petit.
Good afternoon, Tamara Petit with North Miami Code Compliance. This is a new case. April 20th, 2022, I did do an inspection at the property of 365 Northeast 125th Street. While conducting it, I did discover that the Malaki Condominium Inc. did not have a certificate of use or a business tax receipt. And as of the final recheck of August 5th, they did not obtain a certificate of use or a business tax receipt.
And this was noticed correctly in accordance with the regulations for today's hearing.
Correct.
Officer Petit.
Yes, sir.
And since this is a new case, have you spoken to anyone from Malki Condominium, or have they reached out to you, or?
No, they have not. And no, I haven't spoken to anyone.
The order will be the same in both cases. I think that based on the unrebutted testimony and the evidence, all accepted into the record, and the officer's, a statement, all unrebutted. Malki Condominium is in violation of not having a BTR as required by the regulations. They will have 30 days to secure one. If they do not, there will be a $250 per diem per day fine until compliance is achieved, plus a $100 fee because the violation has been shown. Similarly, Malki Condominium needs a certificate of use. They will have 30 days to obtain the same. They don't have one as required by the regulations. That violation has been shown. If they don't have one within the 30 days, there will be a $250 per diem fine until compliance is achieved, plus the $100 admin fee because the violation has been shown. Thank you.
Thank you.
Item number 40 and 41, Rodrigo Colani and Lisa Leroy. Case number for item number 40 is CEBPR 2022-00342. Previously found guilty with an abatement date of August 5th, 2022.
I'm sorry, just repeat the abatement date. I'm sorry, I didn't hear you.
August 5th.
Okay.
Fine set at $250 plus $100 cost assessment. And as for item number 41, case number is CEBPR 2022-00343. Previously found guilty with an abatement date of August 5th. Fine set at $250 plus $100 cost assessment, and the officers will be arrested.
Officer Perez of the City of North Miami today reviewing the case in regards to the property at 12580 North Bayshore Drive. The first case in regards to an after-the-fact permit that must be obtained for the gazebo that was built. As of my final reinspection, the gazebo does not have permits. The property was posted on July 28, 2022, and it was sent via certified mail on July 29, 2022. As I mentioned, the property is not in compliance. The city asked for the fines to move forward.
Based on the unrebutted testimony, the evidence of record, all of which is accepted without objection, the city has shown by competent substantial evidence that they need a permit for the gazebo. The fine is hereby imposed at $250 per day, effective the day after compliance, day after 8/5/22, and each day thereafter until there's compliance, plus a $100 admin fee.
In regards to the second case, it is at the same property, 12580 North Bayshore Drive. This is in regards to a dock that was built in the property without permits. As of my final reinspection date, no compliance was met. They did not have permits. The property was also posted on the same date, and it was sent via certified mail. At this time, the city is requesting that the fines move forward as well.
Based on the unrebutted testimony and the evidence is that this was unpermitted work that was done for the dock, and there will be a $250 per day per diem fine assessed, effective August 6th and each day thereafter until compliance is achieved, the day after correction, plus a $100 admin fee as the violation has been proved. Thank you.
Item number 44 through 47 is for Sunshine Gasoline. They're all new cases. For item number 44, case number is CEFOB 2022-00159. Item number 45, CEFOB 2022-00160. Item number 46, CEZCU 2022-00307. Item number 47, CEZCU 2022-00308. And all of those violations are for Sunshine Gasoline. And the officer is Shannon Sanders.
Shanna Sanders, City of North Miami Code Compliance Officer. I'll hear the first two for, let's go with Sunshine. Sunshine, the property owner. They're both for 1 Northwest 119th Street. They were originally cited, well, I originally cited them March 17, 2022. It was brought to my attention that mid last year, the city recently annexed, or at that time annexed, another portion of what was considered at that time the county into the city. I was hesitant when I stated that they were noticed because they were giving a notice of violation, if not a courtesy notice, 3 months prior by the previous code officer for that zone, giving them instruction that, okay, you've been recently annexed in. We gave them 3 to 4 months to do whatever they needed to do in reference to obtaining business licenses, getting their garbage and waste pro services, connected and things of that nature. Long story short, I became the officer of this area February of this year, whereas I was instructed to take care of some of the older violations that were in the system. As of that date, I had a conversation with the property owner as well as the tenants and instructed them that time is up. Now you have your official notice. Let's get the time to get the CU and business tax receipt. As of my last reinspection on August 5th, I have not seen and or heard anything about an application being filed, submitted, obtained at all regarding either certificate or document. I am showing proper service was given. I mailed the notice I posted the property. Well, actually, I hand delivered it on July 26th to the store clerk. I am showing that it was mailed out certified mailing on the 28th of July. But again, as of my last reinspection, no certificates or business tax receipts has been obtained for either. And that one is for CEZCU 2022 00. I'm sorry to make sure. No, let's go with gasoline. I'm sorry. This is the Sunshine Gasoline CEZCU 2022 00308. Again, that one for certificate of use, and for the business tax receipt CEFOB 2022 00160, and that one is for the property owner. We also cite the property owner to obtain the certificate of use and business tax receipts for commercial properties.
So my one question I have two questions about that very quickly, Officer Sanders. When the city annexed the property, these people were advised and were told that they'd have to get these permits from the city of North Miami now, and they became aware of that, right?
Yes, they were. From what I'm showing here, they were noticed in October of the new annex, and they were giving time to submit the paperwork to the city. I then became the officer in February. These were open in March. But yes, to answer your question in short, okay, they were given courtesy notices, not violations, courtesies, because again, they were just annexed, so we wanted to give them time.
Okay. So, and my other question is as to the BTR, right?
I'm sorry, what was the question?
You said that you cited the tenant and the property owner.
Yes, but and as you go ahead. I'm sorry.
No, it's all right. Per the city regulations, who is it that's required to have the BTR? Is it the owner or is it the tenant, or do you require one from each?
We require one from both.
Okay. All right. I understand.
Yeah, I would say we require one from both.
So that is the practice, to require one from both.
Yes, because we cite the property owner because yes, the property owner is still a business that is now renting out the different units within, let's say, his bay to rent out for services. So yeah, that's considered another form of business.
All right. Based on the unrebutted testimony and evidence given by the officer and the documents on file, which are all accepted into evidence without objection, and noting the non-appearance of any respondents, I'm going to find that both the tenant, Sunshine Gasoline, and the owner need to get the BTR. They need to have it within 30 days. If they don't have it within 30 days, there will be a $250 per diem fine until they do have the BTR, plus the $100 admin fee is assessed in each case as the violations have been shown. Thank you. Next.
So making sure. So we did the one for Sunshine Gasoline as a property owner in Marathon for the business.
Correct.
Okay. Okay. Thank you.
Item number 48, Victor Diaz, case number CETRE 20210008, previously found guilty with an abatement date of August 5th, 2022. Fine set at $500 plus $100 cost assessment, and the officer is Jose Perez.
Officer Perez with the City of North Miami. Today we're hearing the case in regards to the property at 12885 Hickory Road. This case is in regards to a several trees that were removed without permits. This was previously heard by yourself, actually. And as my final reinspection, compliance has not been met. They have not obtained the after-the-fact tree removal permits. The property was posted on July 28th and was sent via certified mail on July 29, 2022. At this time, the city is asking the fine to move forward.
Based on the unrebutted testimony of the officer and all the photographic evidence of record and all evidence of record, which is all accepted without objection and is unrebutted, I do find that this owner is in violation of the tree removal ordinance of extensive tree removal without permits. The fine of $500 per day is hereby imposed effective the day after the date of compliance, which would be August 6, 2022, and each day thereafter, plus the $100 admin fee as the violation has been shown. Thank you.
Thank you.
And that concludes all for today's agenda, Magistrate.
Thank you. That's good to know. Let me. I don't care if it's on the record or off the record, really, but just this
recording
is just,
stopped.
All right. Right. Okay. So that we can stop the recording because this is just procedural stuff I wouldn't be speaking about. But I wanted to speak to the director, the assistant city attorney, and the clerk. I don't need the code officers here. They can all go. So okay. So here.
1 second. I'm sorry. Let me.
Okay, sure.